Go ahead. Ted.
Okay. Didn't pop up on, okay.
It's there.
Okay. Good evening, ladies and gentlemen. Welcome to a regularly scheduled meeting of the Zoning Commission of the City of Danbury, June 8th, 2021. This is a web-based meeting hosted via Zoom. Let the record show we will begin at 7:39 with a roll call. Okay. Commissioner Almeida. Commissioner Almeida is here. Commissioner Fay.
Here.
Commissioner Hawley.
Here.
Commissioner Ski.
Present.
Commissioner Jowdy.
Here.
Commissioner Kelly. Commissioner Kelly is here. Commissioner Mazzi is absent. He called in. Commissioner Malillo.
Here.
Commissioner Eriquez.
Here.
Commissioner Marchand.
Here.
Commissioner Nejame is absent. And I am Commissioner Haddad. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. We have 10 this evening, 8 regular, 2 alternates. The next regular meeting is scheduled for June 22nd, 2021. Mr. Malillo, are we all set to do the pledge?
Oh, let me pull that up. Give me a second.
Okay. While you're doing that, Mr. Malillo, let me read the legal notice.
Gotcha.
The legal notice for this evening's meeting is an application to be heard by the Zoning Commission at a public hearing in a web-based meeting hosted on Zoom, June 8th, 2021. The agenda to be posted will include instructions to access the Zoom meeting and application materials. Public hearing pursuant to Executive Order Number 7I, Section 19.c, and subsequent extensions. Notice is hereby given that the following petition will be heard. Petition of D&B Wellness to amend sections 5A, 5F2, 5B, 3B, and 5B, 5F1 of the zoning regulations. In parentheses, delete prohibition on drive-through window for medical marijuana dispensary. Theodore J. Haddad, Jr., Chairman. This was posted on the city website and the town clerk's office on May 28th, 2021.
Okay, we should be good to go with the flag.
If we could please rise and join Mr. Malillo in the Pledge of Allegiance.
I pledge allegiance to the
To
flag
the flag
of
of
the
the
United
United States of America,
States, the republic,
To the republic for which it stands,
one
one nation,
one nation, under God,
indivisible,
indivisible,
liberty,
with
and justice
justice
for
for
all.
all.
Thank you all. Thank you, Mr. Malillo. Commission members, let me move over here, move this over here. Move this over here. Commission members, everyone received the May 25th, 2021 minutes in advance of tonight's meeting. Hopefully everyone had a chance to read them over. Is there a motion to accept the minutes of May 25th, 2021?
I make a motion to accept the minutes.
Motion by Ms. Hylinski to accept the minutes of May 25, 2021. Is there a second?
I'll second.
Second by Mr. Malillo. Any discussion? Any comments, corrections, modifications, deletions? Not hearing any. All those in favor signify by saying aye.
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 For the record, I did not hear any opposition. The minutes are accepted unanimously. Let me read. I already read the beginning of this on the legal notice that this meeting is held on Zoom as a virtual meeting. Access to the meeting or to watch a live stream on the Danbury, Connecticut Planning and Zoning YouTube channel can be found on tonight's agenda. It was posted on the Board and Commission homepage of the city's website. When live streaming and video recording is required to be posted on the city's website, identifies all those participating in the meeting by name and or phone number as it appears. As far as procedure goes, this meeting is held exactly as it would be in the council chambers, except it runs a little bit slower. We look for hands Several of us look for hands. We look for voices. During the public hearing, we asked that everyone's microphones be turned off. What we do is we then listen to the petitioner, a round of questions by commission members at that time, if needed. We'll then ask for anyone else wishing to speak in favor and questions on each person possibly that speaks. We'll then look to those wishing to speak in opposition. When that is concluded with questions, we will have a rebuttal by the petitioner. And then one of two things will happen. By consensus, the commission may elect to continue the public hearing for various reasons or to close the public hearing. The first petition this evening is first public hearing is a petition of D&B Wellness to amend sections 5A, F, 5B, 5.2, and 5B, 3B, and 5B, 5F1 of the zoning regulations. In parentheses, delete prohibition on drive-through window for medical marijuana dispensary. I will read the planning commission recommendation. It's dated June 3rd, 2021. To Theodore J. Haddad Jr., Chairman, Danbury Zoning Commission, from Arnold E. Finaldi Jr., Chairman, Danbury Planning Commission, regarding 8.3A referral petition of D&B Wellness to amend sections 5A, F, 5.2, and 5B, 3B, and 5B, 5F1, excuse me, of the zoning regulations. In parentheses, delete prohibition on drive-through window for medical marijuana dispensary. At the web-based Zoom meeting held on June 2nd, 2021, the City of Danbury Planning Commission voted to give the above referenced petition a negative recommendation for the following reasons, and there are three of them. The first one is, this amendment is inconsistent with the Plan of Conservation and Development, POCD, specifically the Land Development Plan section regarding coordinating land use decisions with transportation systems to ensure roads and highways can accommodate new development without significant declines in traffic safety or efficiency. Number two, approval of this would undermine the existing prohibition on drive-through windows and could impact the compatibility of land uses and result in traffic congestion and safety impacts along arterial corridors, especially Mill Plain Road. Number three, the amendment has the potential to have negative impact on the health, safety, and welfare of the general public and could reduce the protections the city has long endeavored to maintain relative to restrictions on drive-through uses, particularly in the CA80 zone. The motion to give this a negative recommendation was made by Mr. Uris, seconded by Mr. Chiocchio. It was passed by a roll call vote with 4 ayes from Mr. Chiocchio, Mrs. Hofstadter, Mr. Uris, and Chairman Finaldi, and 1 nay for Mr. Salvain. Ms. Calicio, would you please read the staff report?
Sure, thank you. This is to the City of Danbury Planning Commission and City of Danbury Zoning Commission from myself, Sharon B. Calitro, Planning Director, dated May 27, 2021, regarding the petition to amend the zoning regulations, sections 5A, 5F2, 5B, 3B, and 5B, 5F1, D&B Wellness, care of Prime Wellness of Connecticut. We have received a petition to amend the above referenced sections of the zoning regulations in both the CG20 and CA80 zones to delete the prohibition of the dispensing of medical marijuana by licensed medical marijuana dispensaries through drive-in or drive-through uses to patrons who remain in motor vehicles. The petitioner's statement as to why the petition should be granted is contained in the petition. Comments on the proposed amendments. The prohibition of the delivery of medical marijuana products via a drive-through use was included in the petitioner's zoning amendment last year, which such amendment allowed for dispensaries to be located in the CA80 and CG20 zoning districts. In addition to the prohibition of the dispensing of medical marijuana out a drive-through use or window, restrictions on dispensaries included a prohibition on the sale of recreational marijuana. The prohibition on the drive-through use was intended to maintain the distinction between products that could be dispensed out a drive-through use or window, marijuana cultivation, sales, and use for purposes other than authorized through the state's medical marijuana program is still not legal in Connecticut. The distinction between drive-through uses, licenses, and legalization are important considerations as will be discussed below. Drive-through facility or use. A drive-through use is defined in the zoning regulations as a use, either principal or accessory, that dispenses food, beverages, products, or services to patrons who remain in motor vehicles. Drive-through uses are commonly identified by a drive-through or drive-up window. In the CA80 zone, excluding the delivery of drugs by a licensed pharmacy, no use may be accessed by a drive-in or drive-through facility by which food, beverages, or similar products are dispensed to patrons within motor vehicles. As noted above, this prohibition was also specifically identified as applicable to medical marijuana dispensaries. The CA80 zone is along the Mill Plain Road corridor, or an arterial road experiencing a continued increase in traffic volumes. Drive-through uses are also prohibited for medical marijuana dispensaries within portions of the CG20 zone along Main Street. Many of the CG20 zone properties are also located on arterial or collector roadways. Allowing said uses in both zones or portions thereof could affect the character of the area in addition to the generating traffic volumes that could result in deleterious impacts on both traffic safety and congestion. The proposed amendment would allow medical marijuana dispensaries to dispense medical marijuana to authorized patients or caregivers via a drive-through use or out a drive-up window. On its face, this may appear appropriate given the rising use of medical marijuana, compromised patient mobility, and increasing list of conditions for which it is eligible. However, there are greater issues looming and associated with dispensaries providing products via a drive-through use should pending legislation to legalize adult use marijuana be approved by the state. Such legalization would allow dispensaries, after obtaining an additional license, to also sell adult use recreational marijuana and associated products. Hence, perhaps the evasive language proposed to be added to Section 5B3B, General Use Regulation CA80 Zone, medical marijuana by a facility, emphasis added, duly licensed by the Connecticut Department of Consumer Protection, close quote. Legalization. The pending legalization referenced above is entitled An Act Responsibly or Equitably Regulating Adult Use Cannabis, identified as Substitute Bill 888, aka recreational marijuana. This legislation, if approved, would legalize adult use cannabis in Connecticut. The bill is over 370 pages in length and would, as noted, permit dispensaries to also sell adult use cannabis products and become, as defined in the legislation, a hybrid retailer. Therefore, there is potential for a medical marijuana dispensary, if approved with a drive-through use, to dispense products other than medical marijuana out the drive-through window, blurring the distinction between pharmacies dispensing drugs and other retail food and beverage products, e.g. coffee, donuts, and hamburgers. Prohibiting drive-through uses, especially in the CA80 zone, except for drugs from pharmacies and non-food, beverage, and similar products, has been a long-standing position within the city of Danbury, and for which the city recently prevailed in a lawsuit, ECB Realty LLC versus City of Danbury Zoning Commission, City of Danbury Planning Commission. Licenses. Pharmacies are licensed pursuant to Connecticut General Statutes, Chapter 400J. Medical marijuana dispensaries are not considered pharmacies and are licensed pursuant to Connecticut General Statutes, Chapter 420F. Marijuana is still considered a Schedule I controlled substance and is not legally allowed to be sold at pharmacies. Based on the above, the commissions could reasonably conclude that amending the regulations as proposed opens the door for the delivery of cannabis products and other related products out a drive-through use or window in the future. This would clearly undermine the existing prohibition and could impact the compatibility of land uses and result in traffic congestion and safety impacts along arterial corridors, especially Mill Plain Road. In addition, it is also reasonable for the commissions to conclude that should the pending legislation be approved, this petitioner would seek to amend the regulations to alleviate the prohibition in both zones on the sale of recreational marijuana from dispensaries. Drive-through use alternative. Staff recently engaged in discussions with the Medical Marijuana Program Administration staff at the State Department of Consumer Protection, DCP, relative to pending legislation, as well as the dispensing of medical marijuana via a drive-through window under the existing regulatory scheme. State staff indicated while there have been questions relative to drive-through windows for delivery of products at dispensaries since the initial legislation in 2012, they were not aware of any specific facilities that had such windows. And while the existing statutes would not necessarily preclude this method of delivery, additional security and other measures would likely be required by the state in consideration of any licensed facility that did have or wants to have a drive-through window. Staff was informed by the state that while delivery via a delivery carrier of said products is contemplated in pending legislation, existing statutes only allow deliveries to facilities licensed by DPH, for example, hospitals. However, DCP has, during the declared public health and civil preparedness emergency related to the COVID-19 pandemic, allowed curbside pickup at dispensaries and will continue to allow this method of delivery. As such, the commissions can reasonably conclude that curbside delivery or dedicated parking spaces for delivery of medical marijuana from a licensed pharmacy to patrons waiting in a vehicle is a reasonable and practical alternative to the amendments as proposed. Compliance with the Plan of Conservation and Development, POCD. Since this petition is a zoning amendment and not site specific, there is no required finding of consistency with the Land Development Plan map. While the amendments may be considered consistent with the language in the Land Development Plan section regarding changing regulations to address changing development practices, these amendments come with the risk of reducing the protections the city has long endeavored to maintain relative to restrictions on drive-through uses, particularly in the CA80 zone. Parking spaces dedicated to curbside delivery remains a feasible alternative to the amendment while maintaining the integrity of the zoning regulations. Deleting the prohibition for dispensaries may lead to applications for other uses seeking the delivery of food, beverages, or similar products out drive-through windows. This could be considered inconsistent with the recommendation in several sections of the POCD, including the Land Development Plan section, page 14, regarding coordinating land use decisions with transportation systems to ensure roads and highways can accommodate new development without significant declines in traffic safety or efficiency. Conclusion, to amend the zoning regulations, the commissions must find the amendments are consistent with the POCD, meet the purpose intent of the CA80 and CG20 zones, and will not negatively impact the health, safety, and welfare of the general public. Staff recognizes there is a need for the delivery of medical marijuana products from licensed dispensaries to patients with compromised mobility. Based on the above considerations, broader implications of pending legislation, and the existence of a feasible alternative, staff notes its concerns relative to the deletion of the prohibition for this use.
Thank you. Thank you, Ms. Calitro. Regarding 8.3B, Westcog recommendation, they were notified according to the statute, as it was also additionally modified by executive order. We have not received a response according to 8-3B. Not receiving a response in time for the meeting is considered not a negative referral or comment by them. Anyone who wishes to speak in favor of this petition?
Mr. Chairman, if I may, Attorney Neil Marcus, 158 Deer Hill Avenue, on behalf of the applicant D&B Wellness. And just a brief history, which is really spelled out in our petition as the reasons for applying for this zoning amendment. So this commission allowed a amendment to the text of the zoning regulations to allow the applicant to petition the Planning Commission for a special exception for the sale of medical marijuana at 105 Mill Plain Road. And the Planning Commission granted that special exception in February. And actually the project is under construction as we speak to create the new dispensary. And during the hearing before this commission, a number of people, let me go back, let me just say, the staff report properly indicates, and I'll go to the beginning of the staff report. The beginning of the staff report says that comments on the proposed amendments, the prohibition of the delivery of medical marijuana products via a drive-through use was included in the petitioner's zoning amendment last year. Absolutely. We included it. And actually, that was done as a result of meetings with the staff and at the request of the staff, because the building that we were talking about already had a drive-through facility. It was the old Webster Bank. So the suggestion was take out that drive-through window, and the grant of the special exception, the site plan on which it's based, remove the drive-through window. So that's what happened. So why are we here tonight? And of course, you're going to say that the applicant is not consistent. On the one hand, just a year ago, we asked for a facility without a drive-through, and now we've changed our mind and we've come back. Well, actually, the reason we came back, I'll be 100% honest with you, was the hearing that was held before this commission, where a number of members of the public said, well, it's really a shame you've taken out drive-through windows. As far as we're concerned, nobody needs drive-through facilities more than a good number, not most, a good number of the people who qualify for medical marijuana. Now think about it. If you look at some of the diagnoses that allow you to get a medical card to purchase medical marijuana in Connecticut, a lot of these diagnoses deal with pain and pain management. And a lot of that is related to orthopedics. So, we're not doctors, at least I don't recognize any in the picture tonight, but you can kind of assume that if medical marijuana is involved in the treatment of pain and controlling pain, and a lot of people have testified that it does, that it's involved with people who might have challenges, might be disabled, and have difficulty with their mobility. And this was actually brought to our attention by a number of the common councilmen who spoke in favor of the original amendment and said, 2 or 3 of them, it's really a shame you're taking out the drive-through window. One of the, I think Rich Molinaro strikes me as the guy who said that he was a medical marijuana user, and he certainly could appreciate the fact that it would be helpful to have a drive-through window, because apparently Richard is suffering from some mobility issues himself. So we took that all in. We actually listened to the public when they speak, particularly in favor of our applications. And when we finished the special permit, we decided to come back and try to address the issue that was left open in front of your commission. Now, what's a little bit amazing to me is that most applicants I know who have sought drive-through windows do it to increase their sales. So a lot of you know that I represent Dunkin' Donuts, Eddie Batista, in the Danbury area. And in the staff report, there's a reference to an application he made to have a drive-through window for a convenience market in the CA80 zone. So why do people retailers want drive-through windows? Generally, it's nice to say, well, it's a service to our public, but for the most part, they see it as an advantage, a competitive advantage. If I have a coffee shop that has a drive-through window, it's an advantage to the guy down the street who doesn't, because people like convenience. So generally, these applications involve applicants who are saying, I want a competitive advantage. I want to increase sales. I want all of those. All those are the reasons that we need a drive-through. In this case, those don't apply. In reality, this application is done solely on the basis of serving a need. Now, the Americans with Disability Act, and by the way, I'm a little concerned that the action, particularly of the Planning Commission and its recommendation, raises issues with compliance with the Americans with Disabilities Act. Some of you may have heard the word reasonable accommodations. When you apply the American Disabilities Act, you have to figure out reasonable accommodations. How do you get somebody in a wheelchair from the first floor to the second floor? you have a ramp? Do you have an elevator? Do you have a chairlift? I mean, those are reasonable accommodations. Well, that's what this application is all about, quite honestly. The applicant, if we are successful in changing the zoning regulation to allow a drive-through, will spend a fair amount of money now reinstalling a drive-through, redoing this, the special exception and site plan permit. And all of that really is not going to attract more people, because there are, as pointed out in the staff report, there are a limited number of facilities that are licensed, and people will generally go to the facility that's the nearest to them, and they're going to come to us because they have a need, and the need is the medicine. And then I think it's actually quite cruel and harsh to have a position officially in the city of Danbury that we say, well, as well-meaning as all that is, we're concerned someday there's going to be recreational marijuana, and we consider that to be like selling food and beverage through a drive-through window. And for that reason, we're not going to make an accommodation. And that's really, when you boil these reports down and the recommendations, that's where we are. And quite honestly, it's disheartening, because this is one of those rare occasions where I could almost look my applicant directly in the eye and said, this is crazy. Well, you know, these people are going to come anyway. They need you. And of course, that's not the spirit in which the applicant operates. They do see that they serve a higher purpose in this medical marijuana field. Now, the interest, now I have to go back and analyze the reports that you've read earlier. So the first thing is, if you look at the planning report, the planning commission, 3 prongs of the planning commission report. Prong 1 says the amendment is inconsistent with the plan of conservation and development. Well, between you and me, it's not inconsistent, because the plan of conservation and development is the fabric upon which our zoning regulations are based. And our zoning regulations currently allow the sale of medicine at pharmacies in the CA80 and CG20 zones. I mean, to say, well, but we're going to discriminate against this medicine, I don't buy it. I mean, I think I tell you that this is absolutely an incorrect conclusion, and it disregards our own zoning regulations. But it goes on to say that it has to do with coordinating land use decision with transportation systems to ensure roads and highways can accommodate new development without significant decline in traffic safety or efficiency. Well, that doesn't apply here at all. We have a limit. It's not as if all of you who are members of the zoning commission are going to say, wow, there's now a drive-through on Mill Plain Road, and we're going to head over there. You're not. The only people that are going to go there are the people that have the cards to enter the facility in the first place. So the conclusion that we're going to have some impact on transportation systems just is just dead wrong. And quite honestly, you ought to ignore it, unless you think that any people that are here tonight who don't have medical cards are about to run over to Mill Plain because there's a drive-through window. And then again, it says that there'll be significant declines in safety or efficiency, but there's no basis actually in the traffic reports, the Institute of Traffic Engineers, that say drive-through windows are less efficient. A lot of people say they're much more efficient. Traffic moves in and out of the site easier with less congestion on the site when they have a drive-through. And that's, of course, why the retailers like them in the first place. But here is to say that first reason, it's posturing. And one of the famous terms of Judge William Mottolese of the Superior Court, when he says that zoning and planning decisions shouldn't be on what ifs and could be's. It should be on reasonable probabilities and facts. So this is a hypothecation or a posturing of a reason. Number two, approval of this drive-through window would undermine the existing prohibition of drive-through windows and could impact the compatibility of land uses, result in traffic congestion and safety along arterial corridors, especially Mill Plain. Well, that's just not true here, because drive-through windows are allowed for pharmacies. And quite honestly, I agree with the staff report. We distinguish between medical marijuana dispensaries and standard pharmacies. They're different. They're licensed different. But at the end of the day, the drive-through window at this facility, if allowed, will be no different than the drive-through facility up the street at the CVS. It'll dispense drugs that are prescription. Now, the third reason for the for the Planning Commission says that the amendment has a potential to negatively impact health, safety, welfare of the general public. I say it's the opposite. This has a tendency to improve the health, safety, and welfare. Because, quite honestly, if you've ever seen someone who is struggling with mobility, trying to go through a parking lot to get to a sidewalk, etc., you worry about the safety. It's not a pretty picture. And it says that this could reduce. Now, again, the word could is, of course, the Judge Modelly's favorite. He bristles at that. It could reduce. Well, a lot of things can happen, but is it likely to reduce the protection the city has long endeavored to maintain relative to restrictions on drive-through uses? No, not at all. I mean, that's great hyperbole. To the extent that Arnie wrote that, his prose is excellent. However, it just doesn't apply. These are hollow terms when you think about what we're applying for. So I'm very disappointed that the Planning Commission doesn't really understand what we're trying to accomplish with a drive-through window to service the people who are challenged or disabled. Now, going to the staff report itself, the staff report indicates at the bottom of page 1, it says in the CA80 zone, excluding the delivery of drugs by a licensed pharmacy. Well, you can stop right there. That's exactly what we're doing. We are trying to deliver drugs by a licensed dispensary. That's the only difference. So that's what we're proposing. And the rest, you could then toss out the rest of this report, because you could say, this is really absolutely no different. And then it says, no use can be used by a drive-through facility for which food or beverages or similar product. If there's any thought in your mind that we're selling food, beverages, or similar products, I got to dispel you of that immediately, because in fact, we're only talking about qualified medical marijuana, period. So the rest of that paragraph does not apply to this application. And when we go on to the top of page 2, the CA80 zone along Mill Plain is an arterial road experiencing continued increase in traffic volumes. But our facility is not going to do that. Actually, I received in my email today the report from our traffic engineer. We have traffic engineers working on the state highway curb cuts. But it's interesting. The report from our traffic engineer compares an existing bank with a drive-through facility to a proposed marijuana dispensary with a drive-through facility. Without a drive-through facility, but just a marijuana dispensary. And what we've determined is the traffic flow will be 9 cars less during the peak weekday morning, and 21 cars less during the peak weekday afternoon, and 5 cars less midday on Saturdays. So the dispensary will be less traffic than the bank that existed there by permit for many, many years with a drive-through window. So the suggestion that this is going to have a negative impact on traffic in the C80 zone just isn't true. And quite honestly, you can rely on the state DOT because they've already requested the traffic report that will substantiate the grant of our new curb cuts and driveway improvements. Page 2 of the staff report says, second sentence, on its face, talking about the proposed medical marijuana dispensary, dispensing medical marijuana to authorized patients or caregivers via drive-through use. On its face, this may appear appropriate given the rising use of medical marijuana, compromised patient mobility, and increasing lists of conditions for which it is eligible. Again, I wish the report just stopped there because that is absolutely true. That is every reason for why we've made this application, and this commission should approve it. But then he goes on to say, however, and you always worry about the word however, there are greater issues dealing with the possible licensing of recreational marijuana. Well, we're not looking for that. We're not asking for that. And this amendment doesn't allow that. And quite honestly, I understand that at about 2 or 3 o'clock this morning in Hartford, the legalization bill made one step forward. However, in that bill is the right of every town or city in the state of Connecticut and its zoning commission to opt out of the sale of recreational marijuana. So I suspect that the city of Danbury could certainly go in that direction, where we would not allow sales of recreation. But it's irrelevant because quite honestly, if they're allowed, they're going to be allowed under their own rules and regulations. Drive-through windows, no. Drive-through windows, yes. That's not our application. So again, we're going to go into what I'll call hypothecation. It's a great idea. You're going to serve people who need it. But on the other hand, you got to be worried that times might change and you're going to have to deal with that issue at a future point. So therefore, turn it down now. I just don't buy that. I really don't. And I don't buy it because of the people that we're trying to serve. I find that, again, to be cruel. The next thing is, of course, there's a suggestion here in the middle of the page that recreational marijuana is a food or a beverage. And, I don't want to admit to my misspent youth, but as I recall my college days, the recreational marijuana was far from a food or a beverage. So it's not. It just doesn't fall into that category. The license, okay. The next thing is, based upon the above, the commissions could reasonably conclude that amending the regulations proposed opens the door for the delivery of cannabis products and other related products out a drive-through window in the future. Well, I don't think you can reach that conclusion. You can't. I'm not sure. Maybe I give you guys more credit, but quite honestly, I don't think you can reach that conclusion. I'll tell you the conclusion you can reach, that there's a possibility that somebody will apply to us in the future to sell medical marijuana through a window. Because you know what? I got to tell you, the zoning commission in Danbury, in the 1950s, probably couldn't have contemplated the sale of hamburgers and hamburgers and French fries and sodas through a drive-through window. It didn't exist then. But when it came around, it was dealt with regulations. So I'd say you can certainly anticipate somebody's going to come to you with a different idea, but you can't anticipate that you're going to have to allow the sale of recreational marijuana through a drive-through window. That conclusion just doesn't hold water. On the third page of the staff report, it says at the top, it talks about the current license, the current COVID emergency orders. And here it talks about basically allowing curbside pickup and service at the curb. I will tell you that during the emergency orders, the governors, not only of Connecticut, but New York, New Jersey, they basically suspended a lot of the zoning that has existed over the years. They allowed dining rooms on sidewalks. That was unheard of around here. You had limited outdoor dining, but the idea that you'd close off whole sidewalks and put tables and put covering up there, does that mean that in the future now, a zoning commission, can't regulate, the use of the sidewalks as part of the site plan? No, I mean, things will change and they'll change back. The fact that there have been emergency orders is not the basis upon which we're going to have our zoning regulations read going forward. But at the end of the day, this paragraph is very interesting. If you read it closely, it says that we've had curbside parking spaces for the delivery of medical marijuana to patrons waiting in vehicles as a reasonable and practical alternative to the amendments proposed. So when I was a kid in the city of Danbury on Federal Road, there was the A&W drive-through. It's now on the site where Home Depot is. So the A&W was called a drive-in, not a drive-through. It was a drive-in because you parked your car, they had it up at the Lark restaurant on Paid Air as well, and they had car hops. Parked your car, and they brought the tray to the window, and I think they still do it at the Sycamore even today. So why is that different than driving through and picking it up at a window? It's a service to people in a car, and one is self-serve. It's like a self-serve gas pump, as opposed to a full serve where somebody pumps the gas for you. At the end of the day, it's a gas island with gas being vended. So I'm saying the fact that it's pointed out that you can have dedicated parking, you can have curbside service. Why do you have to have somebody bring it out to you? Why can't you just drive up to the person that's going to hand it to you? It's virtually the same. I mean, to me, this is an argument that says you ought to consider this because it works. And it works when there's an emergency situation. Now, and of course, in the rest of continuing down on that page, it says parking spaces dedicated to curbside delivery remains a feasible alternative while maintaining the integrity of the zoning regulations. Well, I'm not sure that that's the case. The fact is that if I could pull up to a drive-through window and place my order, give me my prescription, and then pull up and park, and somebody could walk out of a door next door and hand it to me, what's the difference? I mean, I think we're fooling ourselves. The answer is, if you're looking to serve the public that needs the service, you ought to do it the most efficient way and not the most inefficient way. There's no reason to consider it as a practicable alternative. So in the conclusion actually is the double is the secret meaning of the report. It is buried in here. The staff recognizes there is a need for the delivery of medical marijuana products from licensed dispensaries to patients with compromised mobility. That's the conclusion I get. That's the conclusion you should get. Based on the above considerations, broader implications of pending legislation and the existence of a feasible alternative, staff notes its concerns. Well, it's not based on the other considerations, because what you're doing is you're basically saying, we aren't concerned about buying oxycodone, but we are concerned about how you buy medical marijuana. I mean, to me, that's just a distinction without a difference. And if anything, it really does tend to be discriminatory. that one type of drug has to be dispensed on Mill Plain Road to people who have challenges, physical challenges, different from other types of drugs being dispensed on Mill Plain Road. And, at the end of the day, we'll live with whatever the decision is. This facility will open up and serve a public that it has. We're almost back to where I was years ago at Bethel before the ZBA, when I was fighting to keep the decision of Steve Palmer, the planner, in place and not to get it overturned by the ZBA, because everybody was afraid of having the sale of medical marijuana. It was the great, elephant in the closet, whatever. And we fought that. And we talked about discrimination, and we talked about serving a public. And quite honestly, sometimes you can actually take a little bit of comfort in the fact that you did something right that worked out for the benefit of the public. When the Planning Commission writes me a memo saying that what we're doing here is going to result in uses that are detrimental to health, safety, and welfare, it absolutely kills me that that's what they think we're doing. So to a certain degree, I remember the common councilman who came out and spoke about in favor of this, and I appreciate it. They favored our original amendment. I'm sort of sorry that maybe they opened this window to thinking that this was a good idea. But be honest with you, it is a good idea. It is absolutely not only a good idea, it's the proper thing to do. So we're fighting an uphill battle. What's new for me? Not unusual. I'm going to ask you as members of this commission to disregard what your compatriots in planning have said. But I will tell you, you are at a unique advantage. The Planning Commission didn't hear the Common Council members. The Planning Commission members didn't hear a detailed description of how this will work. Who will use the drive-through window? How restricted it is to the general public. It is. It's really. It was a decision, I think, that was made substantially in the dark. But you guys, members of this commission, have been with this thing now through 2 hearing processes. And I think you got a fair idea of what we plan to do. And we're not going to, open a floodgate for problems. What we're going to do is try to serve people who need it. And we're going to go to a fair amount of expense to do that. And at the end of the day, I hope that the commission sees fit to allow it, because it's just the right thing to do. The bottom line, it is just the right thing to do. So I'll be happy to answer any questions. We have on the screen Carl Torella from D&B. I don't know that he has anything he wants to add. He's certainly free to do that, but he'll answer any questions operationally that you might have. Thank you.
Thank you, Attorney Marcus. Attorney Marcus, before I move on, let me go back and forth with you on a couple things. If you can
Yes, sir.
confirm whether I'm correct or not, and I want to do this for the rest of the zoning commission members. Your most recent visit last month to the planning commission was based on, it was a referral only, it wasn't a public hearing, and it was based on the deletion of the drive-through window. Last December through March was the actual public hearing, which you made your presentation, just like our public hearings here, where there was input from those in favor and those opposed. And that was to allow it. It was for a special exception to allow it. So commission members, the testimony that Attorney Marcus is talking about or referring to was during the public hearing petition that the Planning Commission heard, which was to allow it. which was to allow it as a special exception, because the last time they were there, it was only a referral and it was not a public hearing. That's correct, Attorney Marcus?
Commissioner
That
Haddad,
is-
may I jump in?
That is correct.
Commissioner Haddad, may I jump in for a clarification or a follow-up? I'm actually thinking that I think Attorney Marcus may have misunderstood your question, and you might be thinking of a different thing. I think Attorney Marcus is referring to the public hearing that the Zoning Commission held not so long ago, where a couple council members mentioned the drive-through possibility when the Zoning Commission amended our zoning regs to allow it as a special exception, but not these public hearing in front of the Planning Commission to approve the special exception where the drive-through comments were made. Is that correct, Attorney Marcus?
Well,
Actually,
Marcus was talking about, Attorney Marcus was talking about the Planning Commission when they had presented in December. Mr. Molinaro spoke, Mr. Chianese, I think Mr. Perkins, Mr. Rotella. I think they spoke at that meeting. Was that the one you were referring to, Attorney Marcus?
actually, I think they all spoke before your commission, the hearing to allow the use to begin with. By the time we got to planning, drive-through windows were off the table. We didn't really discuss drive-through windows at planning. They were already off the table because we never put them in the original zoning regulation. But they did, by the way, they all spoke in favor. A lot of them came back at planning and spoke in favor of the use and the proposal. But the specific testimony I was talking about, and Bob is correct, was before this commission in allowing the amendment for medical marijuana facilities to begin with. And the comment was, it's really a shame you specifically exclude drive-throughs. They could be they could be important here.
So-
They could be proper.
When was it last at this commission? When did we have it? Well,
It was,
it was before the plannings on December 2nd, right?
yeah, it was before your commission about 4 months earlier.
Okay, so,
During COVID, I remember that because I remember sitting here on the computer listening to it.
okay,
Yes.
so we heard it somewhere around September of last year, I think, and then planning had a public hearing in December of last year.
That is correct.
Then that was on allowing it. And then the last one that came up was last month, planning for the deletion of the drive-through window, and now it's before us after hearing their referral for deletion of the window. Right?
Correct. And it's in that referral that we don't participate or
Yes.
explain anything about what we're doing.
Okay.
Mr. Chairman, just for the record, so the amendment was effective 6/17/2020.
Boom.
The amendment to allow the dispensaries. So sometime last June.
Great. Thank you very much.
Thank you.
I know that on the December public hearing, you had mentioned that the window was boarded up and the only question was the canopy, but you quickly added at 28:55 of the YouTube video that you will not have any sales conducted through the window at all. It's not your intention. And it was at 33:08 that Paul Rotello, Councilman Rotello, the only person until March to speak about the drive-through window, spoke of it only that it would be useful because of COVID. So I don't know if I haven't heard anyone else speak about it. You said many people spoke about it. But I only heard Councilman Rotello speak about it, and he's here tonight, so I'm sure he's going to speak anyway, and I'm sure he'll give his position. So I wanted the zoning commission members to know that the last go around, which was in relationship to the drive-through window that planning heard, was a referral. It was not a public hearing. The comments Attorney Marcus was talking about during the public hearing was either the zoning commission public hearing in June or the planning commission public hearing in December, correct?
Correct.
Okay, thank you. Commission members, any other questions of Attorney Marcus at this time? And we're going to circle back if we have to revisit Attorney Marcus. Is there anything, commission members? Ms. Melillo?
Attorney Marcus knew I was going to ask him because based on the last public hearing, he said he's yet gone without me asking him at least one. I actually have at least 3 questions. First, Attorney Marcus, I'm curious about something. And this is from my ignorance. I don't know, or I'm not sure what the best definition is. But so when we're dealing with medical marijuana, does that come in the form of edibles?
Yes,
So is edibles food?
no. When you look at the Danbury regulation dealing with pharmacies, that the fact that a medicine is chewable doesn't make it food.
Okay. Because I was when I was sitting here wondering if some attorney in a future hearing might argue that we're already allowing food through these things or sorts of food because we're allowing edibles and therefore try to use that to backdoor it in. I was just curious.
By the way, I think, with all due respect, I think that the last amendment dealing with drive-throughs in the CA80 zone clearly, when they allowed it for pharmacies, talked about the very thought you had that there could be a pharmaceutical, but as long as it is a pharmaceutical, a prescription drug, whatever, the manner in which you ingest it would not be determined as food.
As I do remember thinking about the liquids on that public hearing vaguely. I couldn't remember from other sorts of chewables.
Yeah, Pepto-Bismol is not a great beverage.
Also, I might have to put my glasses on. I unfortunately my handwriting tends to be small and my eyes don't see it as well anymore. Where is the next nearest medical marijuana dispensary in relationship to Danbury?
Well, right now the applicant operates on Gorilla Road up in Bethel.
Right. No, but he's going to close down when he moves to Danbury. So
That is correct.
Counting that location, because that's going to move to Danbury. Where would the next closest one be?
I'm going to have to see if Carl Torella is listed.
This is Carl Torella, 7 Forest Ridge Road, Nyack, New York, 10960. The next closest one to would be Westport plus Stamford. They're fairly similar in distance to our location. There is a second one moving to Stamford, probably in the September timeframe.
Okay.
Thank you, Carl.
The reason I was wondering was because I was curious as to what thinking if you have an option of a facility with a drive-up window and an option one without a drive-up window. I know some people who specifically choose which Dunkin' Donuts, for example, they're going to visit based on whether or not there's a drive-up window. So I was just thinking if it's not that far out of the way, that it might be a traffic generator, but for that distance, I can see it not being one.
Thank you.
And Mr. Melillo, I think it's important to note here that every patient in the medical marijuana program has to choose a dispensary, and they're really put into one only dispensary. So once they choose that dispensary, unless if they apply to the state, they cannot switch dispensaries. So the traffic flow is pretty defined in terms of patient count.
Okay. And you may or may not know the answer to this question, and you didn't necessarily raise it. It was in Ms. Calitro's staff report, but she alluded to some additional security measures that would be required by the state with a drive-up window, or potentially would be required by the state for a drive-up window. Do we have any idea right now what those security measures would be?
So actually, Mr. Melillo, I don't think that there'd be additional security measures rather than just having the same type of security cameras at point of sale. There's an important thing to note here is that 2 personnel are actually required for curbside in the parking lot right now. So it's a little more unsafe than, and with product bringing out to the parking lot, and a little more inefficient rather than just having the product dispensed from a restricted area within the facility to the patient's car under surveillance cameras, similar to how it's done today.
Okay, thank you. I have no further questions, Mr. Chairman.
Thank you, Mr. Melillo, Mr. Torella, and Attorney Marcus. Any other?
If you don't mind, I'd just like to say a few more things prior to additional questions, just so that you have it on record as well. I think an important thing to note with the medical marijuana program is that we actually have licensed registered pharmacists on staff required by DCP. So while we're not recognized as a pharmacy by the state legislator, we actually act in tune as a pharmacy because we are required by the DCP to have pharmacists on staff to recommend products and talk to our patients. So I think that is a thing that we should all consider here, is that we truly do act like a pharmacy because we have pharmacists on staff and required to by legislation. We have to sign, all patients are required to choose a dispensary. So we have a defined amount of patient count within our facility. So opening a drive-through is not going to get somebody to drive an extra hour from the near closest dispensary just because we have a drive-through. It will expedite the traffic. So our normal on-site during pre-COVID was about 15 minutes inside the dispensary. During COVID, I've had people super scared to come into the facility, both from patients and employees, because of the interactions that we've had here. And I pivoted from my career personally from corporate finance about 18 months ago to the operational retail and helping people, because that's what we can do here. And this is at our cost. It's not going to increase sales for whatever reason to our business. It's actually just going to help our patients here in terms of their ability to have accessibility to the product in a safe manner. And then most importantly, it's going to help our sick individuals who have cancer, who have hope for the first time in 18 years, somebody told me the other day. I mean, those are the things that I strive to do for my patients and keep our facility the safest for everybody involved. So I think that we should all take that into consideration, because it's really not going to increase business or traffic flow here, rather than help the facility and the patients that needs. And that's why we originally got access to medical marijuana in the city of Danbury, because I think everyone realized it was time to help the patients. And that's what we really need to do here.
Thank you, Carl.
Thank you. Attorney Marcus, did you have any, commission members, any other questions of Attorney Marcus at this time? Attorney Marcus, did you, Ms. Hylinski, unmute?
Attorney Marcus, I'm a little confused. Can you hear me?
I can hear you.
Did you say you did a traffic control? Because I'm a little confused with the traffic, and yet we don't know how many patients are going to be picking Danbury as their dispensary. So how do we know how much traffic is going to be coming and going?
Well, what I was referring to, Angela, was the state traffic commissioner is requiring us to give them trip generations. That's a sheet here that I received today from Michael Galanti, our traffic engineer. And it was not given to me for purposes of tonight's hearing, but it was just to show the information that he submitted to the DOT. And I looked at it and I said, well, that's very interesting, because I just read the issue of traffic in the both in the staff report and in the planning commission referral. And I said, Michael Galanti, using the Institute of Traffic Engineers numbers, has determined that medical marijuana during peak hours will generate less than a bank during those same peak hours. But if you want to know overall how many patients will use the Danbury facility, Carl may be able to give us a ballpark figure based on how many people are choosing Bethel. Can you do that, Carl?
Yeah, so Ms. Hylinski, we service about 250 patients a day. Obviously, it's hard to tell how many of those patients will transfer to Danbury when we move 8 minutes down the road. We hope that almost everybody will continue to do it because it's a more modern facility. We're operating out of a 1,400 square foot house right now. So we're really excelling at our customer service and patient care. And this is just another step forward for us in trying to help them out.
But the number, Angela, that you were looking for is approximately 250 per day.
Yeah.
Thank you, Carl.
You're welcome.
Anything else of Attorney Marcus at this time? Attorney Marcus, I don't want to put words in Commissioner Helinski's mouth, but I think what she was looking for was when you read off the numbers that during peak, there will be 5 less cars. During off-peak, there'll be 10 less cars. It's less than what? I mean, what's the whole number that you have there that you were given that then it's going to be 5 less than what?
Well, okay, I'll give you the number real quickly. A bank use at that site was weekday peak traffic was 37 car trips during the peak hour, weekday. And the comparative was that medical marijuana would be 28. So that's the minus the difference between the 37 and 28 is the -9. And similarly, in the afternoon peak, the bank would have generated 77 cars and the medical marijuana would generate 56 cars. So there was a difference there of 21 cars. But that is not a specific count. Those are ITE numbers that they use, but they're pretty well accepted. And actually, by the state DOT, they're very well accepted.
Got it. Ms. Helinski?
Thank you.
Thank you. Any other questions of Attorney Marcus at this time? Any other questions? Attorney Marcus, do you want to call any other presenters? Do you want to have Mr. Torella? Did he have more to present? We were
I
taking.
think I'll ask Carl, you have anything else you want to say at this point?
No, I think this is just really want to hammer home. We're doing this for the wellness of the patients and nothing else. I mean, this is not a business decision whatsoever. It's really for patient accessibility and patient care services here. So I just ask everyone to take a step back and realize that here first and foremost.
Thank you.
Thank you.
Well, the applicant will rest at this point, but we're here to respond to any comments or questions.
Let me ask of Mr. Torella if I can. You're obviously moving from Bethel, a smaller facility, to Danbury, a larger facility and more modern, and probably with an opportunity to make it more high tech than a ranch house.
Yep.
So I know that you had testified before saying between 250, 275, as much as 300. So I have a couple questions. And I also know that you said that once someone selects their dispensary, they're there to stay. They can't bop around back and forth. So that's all well and good. You want to bring your customers with you, but on a going forward basis, you will always have new clientele. And it's that new clientele that's going to drive up the numbers from the 250 to 300 to more than 300. That would be locally. To center in on my question, can a doctor in New York State prescribe medical marijuana and have a customer from New York also select your Danbury location?
No, it cannot. You have to be a certifying prescriber in the state of Connecticut, and you have to select one dispensary. There's no reciprocity of state license, a medical card in New York that would be accessible in the state of Connecticut.
If someone lived in New York, but their physician was in Connecticut, can they prescribe to that person and have them select you?
No, it would have to be a Connecticut resident.
Connecticut resident only, Connecticut physician only.
Correct.
You said also, I heard you were talking about having some type of training facility on your second floor at some point in time, maybe an educational type of a forum or meeting room. Could your dispensing facility be expanded into that second floor?
Theoretically, it could, but we would need to be ADA compliant in terms of the building. So we would have to do some things in terms of the zoning board. So right now, wouldn't be able to do so. But I mean, I don't foresee that happening in terms of our business plan. Obviously, our second floor will be utilized for patient support groups, educational trainings, and things like that for our patients that we're currently doing in the state.
And also, I saw at one point you had mentioned that I think one of the people here this evening had asked, what do people do if there's too many people inside, you said you were going to consider putting up a canopy along the other side of the building that didn't have the window where the parking spaces were, and have people wait underneath that canopy for permission to enter?
Yep. Right now, we're going to be holding about 20 to 25 people post-COVID, obviously, depending on what the laws are inside the facility, which at maximum time should be enough space to properly adhere to our patients at any given time. Obviously, if there's an overflow, we expect the line outside the side of the building to cover. We're also implementing technology for check-in at the facility so people can stay in their cars if need be, and we can text them and or email them or call them, whatever it may be, so that they come up to the door when it's their turn.
Your Friday is the busiest day of the week?
It's dependent on the time of the month. I mean, flows, but I mean, yes, usually Friday nights, and then obviously some of the producer days, depending on deliveries earlier in the week.
So your 300, your high end, your 300 would be on a Friday. Whereas
Servicing 300, obviously there's hours that are going to be more demand than certain hours throughout the day. But I would say probably Friday between 9 to 10:30, and then maybe kind of 4 to 6 when we're closing before. And then obviously, since we're closed on Sunday, if we get a delivery on Monday, it may tend to be a little busier then too.
Are you closed on Sunday by regulation or by your preference?
By choice. I believe there's only one producer in the state that's open on Sunday.
And your normal hours are 9 to 6?
9 to 6 Monday through Friday, and 10 to 3 on Saturday. So it's a short Saturday.
Got it. Thank you. If I could go back to what Commissioner Melillo was asking, you don't dispense any products that's food, edibles, or you do?
We do dispense edibles. Mr. Marcus, I mean, obviously, in terms of the legality of it, a way that Connecticut law, I'll let you speak to that. But we do dispense edibles.
What's an example of an edible?
A brownie.
Okay. So it's not like a chewable gummy or anything. It's actual food. It's brownie.
Yeah.
Okay. Okay. I think for now I'm good. Ms. Hylinski.
Mr. Torella, my question is, now in Bethel, do you have someone, an employee, that if there's someone in a car that's disabled or not able to really come inside, you have an employee that would take their package, their prescription, and bring it to them outside?
Yeah, so the way that the curbside works, it's required to have 2 facility members deliver that package to the car. It has to be a security member plus either a dispensary technician or a registered pharmacist. So every single curbside transaction that happens is really taking an extra employee away from helping the patients on site, because it takes time to walk back and forth to the cars and things like that. And obviously it would be more efficient for everybody's standpoint if we were able to just have one employee at point of sale through the drive-through complete that transaction.
Well, okay, but you will at Danbury still have that available?
If we don't have a drive-through, yes, we will,
Right.
obviously. I mean, for safety reasons, it's worse than what a drive-through would be, but we would continue to offer that as long as the DCP allows us to. And there's no indication that they're going to take that away from the patients because of what has happened over the last year.
Thank you.
You're welcome.
Thank you, Mr. Torella. Thank you, Ms. Hylinski. Mr. Melillo.
Yes, Mr. Terrell, I have another quick question. I actually thought about it while during the last bit of conversation. Is it required that the patient be present to pick up the prescription, or the prescribed medical marijuana, or can they have, if they're not able to get out of the house, can they send somebody to pick it up for them?
So it's required that a patient and or their caregiver, who is also registered by the state, pick up their medication. So if you were a medical patient and you wanted your wife to go pick up your product and she wasn't a registered caregiver, she wouldn't be able to do so. You would have to go through the same type of registration with the state and the background check and whatnot to have her added to your account in order to do so.
And that's been acceptable under the ADA precautions.
Yes, I believe.
But like nobody has claimed that that is in violation of any ADA laws.
Not to my knowledge.
You all set, Ms. Malillo?
Yeah.
Thank you, Mr. Torello. Thank you, Ms. Malillo. I see Mr. Almeida, please.
Yes, I just had a quick question. I'm not sure about this, but doesn't the state regulate like how many dispensaries are allowed presently?
Yes, there's 18 dispensaries, medical marijuana dispensaries allowed right now. There's 4 producers with the option to go up to 10 different licenses in the state.
So the possibility of Danbury having a second dispensary presently is quite low, right?
Right now, it wouldn't be possible until new licenses are issued, obviously with legislation pending.
Right.
All our best guess on what that will look like.
So in all likelihoods, this zoning change that we're considering tonight would only impact the one dispensary presently in the city.
Correct.
Okay. That's all I want to know.
Well, also, let me say that at one point in time, wasn't it 6 growers and 6 dispensaries, or 3 and 3, and it was raised?
So the program started back in 2014 with 4 producers. Those 4 same producers are the same producers today. It hasn't been raised in the 7 years of the program. There is an option to go to 10 by the DCP, but because of supply, they haven't done so. The initial program for medical marijuana dispensaries started with 6, went to 9 in, I believe, 2018, then doubled to 18 recently, a few years back. And it has been capped with no indication that that will be increased in the near future.
Thank you for that accurate answer, but anyone that wants to think that they could speak on behalf of the state is mistaken. They say that they have no plans. They plans 3 other times. And we saw that happen with the teletrack. We saw that happen with the gambling. And we can also see that if it's, and I know Attorney Marcus doesn't like to talk about what if scenarios, but if by midnight tomorrow night, the state passes recreational, then if this drive, the way I see it, not finished hearing yeses and those in favor, those in opposition this evening, but it seems likely that if this petition passes tonight, someone that's going to be coming in for recreational, which would be allowed by population, which if Danbury does not opt out, would allow 15 recreational marijuana stores in Danbury, they would be looking for the drive-through windows as well. So that's something that maybe will happen, maybe won't happen. But for anybody locally to hold their hopes on what the state is going to do, I think are quite mistaken. Anybody else wishing to speak? Mr. Almeida.
But yeah, just I guess a point of clarification on that. We only allow presently medical marijuana dispensaries. For recreational use, it would have to come in front of the zoning commission to be approved, wouldn't it?
Yes.
Yeah.
Yes.
Okay, so I mean, we can consider that at a future time, the drive-through and all that.
Yep, absolutely.
Okay.
Absolutely.
It's not an automatic, right. Commission members, anything else? Mr. Hawley.
Go ahead, Mr. Hawley.
Yep, thank you. So how many people currently utilize the curbside pickup option?
Yeah, that's a great question, Mr. Hawley. Obviously, there's only a certain number of conditions that are eligible throughout the curbside that we currently offer, and those are your normal immunocompromised, over 65, disabled, cancer patients, all those types of things. And currently on our staff, it's our patient count, it's about, I would say, anywhere from 150 to 200 from a curbside pickup. And we do limit those for timeframes within the facility. So I would foresee us doing the similar type thing. Every 15 minutes, a person's coming through drive-through. It's not, you come at your own leisure and you back up the whole parking lot, right? So, I mean, we would be doing it every 15 minutes or every 10 minutes, whatever we deem possible in terms of the transaction count there for our medical patients, and create that efficiency there.
right, thank you. And have there been any reports of like any kind of accidents or anything in your parking lot due to the curbside pickup that could have been avoided by a drive-through?
There have been accidents, but I don't think they're attributed directly to curbside, to be honest.
Okay, thank you.
You're welcome.
Thank you, Mr. Hawley. Thank you, Mr. Terrell. Ms. Calitro, did you have something to say?
I just wanted to clarify again, I mean, the proposed pending legislation changed from Thursday to Tuesday. So unless, as we were talking about, would they have to come back to the zoning commission? They may not have to. If we didn't do anything and we didn't regulate it, then it had to be treated like any other retail use, which would not require coming back to the zoning commission for approval for recreational marijuana.
Oh, okay. Well, thank you. Mr. Melillo, you also had your hand raised. I'm sorry, Ms. Fay. Ms. Melillo, let me let Ms. Fay in. Ms. Fay, please.
Yeah, I'm just curious. I know this isn't a site-specific petition, but at 105 Mill Plain Road, what would be the traffic pattern in and out?
Yeah, so you'd be making a turn into the facility. It would be the left-hand, right-hand turn into the entrance of the facility. But as one of the site plans revisions that we initially had, we made it only a right turn out around the facility. So it'd be a one-way around the full facility, and you'd be making a right only outside the exit of the facility onto Mill Plain.
So regardless of whether there's a drive-through, you envision it going in one side of the building? Isn't the driveway only on one side of the building at this time?
No,
No.
the driveway currently loops around the building.
Huh.
It's a horseshoe. Remember, we had, the bank had a drive-through there for many years on the west side. And that basically, that was 2 lanes, one through the drive-through and one for an exit.
Okay.
So we would, if we had a drive-through, we would have a similar pattern.
Okay.
And just add one thing to Ms. Calitro's comment. The bill does say that the local zoning is required. So as of the last change that we've had as at least the way that my lobbyist, my legal team, and I have read it, the local zoning is required for the bill and recreational use.
I'm sorry, say that again, clarify that again.
Local zoning is required for recreational use, the way that the bill stands today.
Right, but that doesn't necessarily mean that somebody needs to come in through the zoning commission as it reads today.
Okay. I think, I mean, obviously, we can go back and forth on this one, but I think that the local zoning committee would be needed in order to put recreational use in their city or ordinance.
And additionally,
That I'm not debating that.
Okay.
That's clear. If you want to
Okay.
change the zoning regulations, you go through the zoning commission, no doubt about it.
Got it.
additionally, if they do take an action on it before midnight tomorrow night, they also can change it too.
Yeah, right.
From what we saw an hour ago.
It changes every hour. It changes every minute.
Mr. Melillo.
Yeah, it's actually inconsistent with those lines. I just wanted to remind the commission that one of our jobs is to think long-term and what potential impact could be. There have been times when, the excuse has come through that something's done that wasn't necessarily the intended impact. And we're like, oh, well, we weren't anticipating that. We wouldn't wanted that to happen. And there have been times when we say, well, you should have anticipated that. It's too late now. It's the law and it can't be changed because it's what's allowed. And so I think I mentioned that now on the record during the public hearing, because I think we do want to consider that. We can't just say, here we're talking about a petition that's only going to potentially impact one facility in the city of Danbury. It could potentially impact more than one facility in the city of Danbury based on legislative action, which may or may not happen. But realistically, I think if the state of Connecticut continues to move in the path that they're moving, I would say it's more likely than not.
Thank you, Ms. Melillo. Any other questions at this time, commission members? Before I go on to anyone else wishing to speak in favor. Anything else? I don't see any hands. I don't hear anybody. Is there anyone else wishing to speak in favor of this petition? Councilman Rotello.
Thank you, Mr. Chairman. Good evening.
Paul Rotello, for the record, 13 Linden Place, Danbury. They didn't go through the minutes or look at the video file for last June's zoning commission meeting, but I do recall, just off the top of my head, I wasn't even prepared to mention this tonight, but it's come up and I've been mentioned. I do recall supporting the zoning commission's change to allow medical marijuana in Danbury and expressing some regret that it did not include a drive-through window. And my hope would be that at some point in the future, and I might have even mentioned a year, I don't think that I did, but I might have, but at some point in the near future, the zoning commission would reconsider. I recall saying that. I'd have to go back through the thing and actually see what it was, but that was my intent anyway, and my feeling back then. And it still is today. And here we are. It's a year later, exactly a year later. We're right back where we started. Boy, you know, there's a lot of what ifs and could be's. I mean, look, the state of Connecticut could, when they do reconciliation, could ban recreational sales through drive-up windows. I mean, if you want to speculate about what the state can do and use that to paralyze yourself about what you need to do tonight, you can do that. It's a free country, and you guys have the legislative authority to make those decisions. But I think what we're looking at tonight is something a lot smaller in scope. We're looking at an extremely vulnerable population that needs medicine, and how do we distribute that medicine in a way that accommodates them in the most efficient and best possible way. And if we do that, does that then outweigh these what ifs and could be's and potential externalities? Or does the fact that a guy in a couple of years might come to you and say, you know, they're selling gummies, so I ought to be able to sell donuts, does that obviate the need of someone with a compromised immune system or mobility issues? Does he or she then take a back seat because somebody on Mill Plain might come in front of you and say, well, you know, they're selling gummies at the pot dispensary, so therefore I ought to be able to sell donuts? In my opinion, and it's just an opinion, that's not even a contest. We shouldn't even be considering that. I mean, that's one of those almost sophomoric late night dorm room conversation. Gee, you know, I guess you can eat a gummy and therefore it's a food, and therefore somebody else could come along in a couple of years and use that as leverage to force our hand. I'm not saying it. I'm not saying that somebody might try to pull that, but the scope of this is so narrow, it precludes that. The response to that would be, sir, your donuts contain medicinal marijuana, because if they don't, you can't sell them through a window. That's what this is for. It's for the distribution of medicinal marijuana, and whether it's infused or it's sublingual or it's ingested or it's a suppository or it's a headband or it's a nebulizer is irrelevant. The relevancy here is a product that has been determined, not by me. I don't have a stake in this race, but the product has been determined, but anecdotally by the users and by some science, as to provide a level of relief that is essentially unattainable in other areas. How do we get this, assuming that that's the case? And I don't think we're here to argue that. I'm not here to argue that. I don't have the science anyway. I'm not a biologist or a doctor. I've got to take people's words at this. But if that's the case, how do we then provide that product to the people who need it the most? There's a whole state system set up to answer that question. Already been done. We don't even have to do any work. It's already been done. They've got the pharmacists on call. They've got levels of afflictions that are morphing and changing. It started with a couple of things, and as they got more comfortable with the product and more research came in, they expanded it to other things, and it is providing relief. But there will be a subset of people that are going to have extreme difficulty attaining it. You can't send your wife to get it for you. You can't just say, hey, honey, go down and get my medicinal marijuana because I just don't feel like driving my car. I can't get out of my, you can't do that. And that's assuming that you have a husband or a wife or a child or something like that who can accommodate. Like my mom calls me up and says, my prescription's ready at CVS. Can you go pick it up? Yeah, sure. I go to the window and I pick it up for you. You can't do that with this product. It has to be the person or a certified caregiver. And those certified caregivers, they're not free. You know, they don't, there's an expense involved with that. So we have a chance tonight to make this as friction-free as we possibly can for some of the most vulnerable people in our community. That's what we do as a government. That's why we're here. And we have a chance tonight to make that decision and to send that statement that in spite of the what ifs and could be's, and if you want, you can continue this until 2 weeks, and then we'll know exactly what's in the 297-page bill. So you won't have to have this conversation, you'll just know. But if you wanted to do it tonight and close it down tonight, you could make a statement that Danbury is a caring community. I would like to be able to make that statement. I think it is a wonderful thing to be in public service and to be able to deliver a product like that that goes beyond the scope of filling a pothole or making sure there aren't mushrooms growing out of school gutters. Not that those things aren't important, but sometimes there are things that are even more important than that. And it's one of the reasons why many of us went into government service. The staff report mentioned traffic, the intersection. I spoke to the traffic, Abdul Mohammed, recently. I got a query from a constituent, lives on the west side. They were concerned that if the dispensary opened, they would not be able to cross Ridgeberry Road and Route 6. I was unaware of the situation on that intersection for pedestrians. It's not something that I've ever crossed myself, except maybe once, and I just dashed across the intersection. But I spoke to the traffic director, Mohammed, and I received a response from him as it happened, coincidentally, this afternoon. And I'm not going to read you the report. It comes with the diagrams, the blueprints for the intersection changes. But I can tell you that in addressing the traffic issues that were raised in the staff report, there will be substantial changes made to that intersection. And they're not limited to the following. Part of the concerns that you had brought up to my attention, east-west, that would be across Old Ridgeberry, and north-south, which would be Route 6. Pedestrian amenities, including crosswalks, ramps, and don't walk displays are planned for installation at the intersection in the very near future. And I believe that also includes these things that they call those things that hang out over the street. They actually have a name. I don't know what they are, but they mentioned that you're going to get a couple of new ones in there. So you're looking at some traffic calming and some accommodation for pedestrians, which will have a direct impact on people accessing this dispensary, regardless of whether they put a drive-through in there or not. But I think that goes a long way. At least it would be to me, for me, a long way in answering the concern about item 1. Item 2 was the a prohibition. Well, let's go to item 3. Item 3 is basically the health, safety, and welfare. I found that provocative in the sense that this is designed to address health, safety, and welfare. It's designed to attenuate problems of health, problems of safety, and problems of welfare. I mean, we've heard tonight that there's a chance that curbside pickup will continue. I'm not at all convinced that that's the greatest idea. I mean, it's nice that they accommodated some of these patients during COVID with that olive branch, but I think that for safety reasons, I would not, as a policymaker, I would not say, well, let's just have curbside pickup. It seems to me, and this is before I even found out, it requires 2 people walking the product out to the car, taking somebody away from dealing with patients. Before I even knew that, it just seemed to me a little dicey in terms of danger. But I guess if you're weighing that against COVID, it probably made a little bit more sense. But now that we seem to have gotten a handle on COVID, let's hope anyway, I would not be surprised if we're spitballing here that they would reduce or eliminate the ability for people to do curbside pickup, which would put us back to where we were pre-COVID. No drive-through, no way of attaining this product without exiting your automobile and standing in line and inclement weather and waiting to get into the building, which is what this whole drive-through window would prevent. There was talk about a Schedule 1, that it's still Schedule 1, and it's true, it still is Schedule 1. And I think this was brought up in the Planning Commission hearing that even though other states have legalized marijuana, they're sort of thumbing their nose at the federal government. Well, they are and they aren't. I mean, the Justice Department is now on record as saying that they will refuse to prosecute. So we have a Schedule 1 technically in the United States that the state of Connecticut is about to violate if they legalize marijuana. But we have a Justice Department under orders from the president. And by the way, I don't believe, and Attorney Marcus can jump in when he wants to, I don't believe there has been a prosecution of a state for allowing medicinal marijuana or recreational marijuana in either a Democratic or Republican administration. I don't recall Trump doing that. I certainly don't recall Obama doing that. And obviously Biden has not done that. It would have been front page news, particularly as it would result in a question about the validity of Connecticut going forward with legalization for recreational. I think that's a canard. I don't want to be pejorative, but I think that, by saying that the federal government doesn't really allow this, so we probably shouldn't either. We're on thin ice. I think at this point in time, the federal government is allowing this. And I think, again, if we're going to what if, and this seems to be an evening of let's just talk about what could conceivably happen, because it's going to affect this, and it's our job to think deep thoughts and go way far into the future. It would not surprise me at all if the federal government itself legalizes marijuana, and that would be that. Now, look, assuming the bill is reconciled in the way that it seems to be going, and again, I will stipulate that it can change, it will be under your purview to prevent any sales anywhere in the city for recreation. If you truly believe that by allowing window sales, you can create a snowball effect, and 15 recreational dispensaries are going to be selling recreational marijuana out their windows, you can simply prevent them from doing that. And that will be that. If that's your concern, I'm on the city council. I can't stop them. If that was my concern, I might be chewing my fingernails. Oh my God, what are we going to do? If we allow this at the old bank, it's going to pop up everywhere. It's going to wind up in my neighborhood. It's going to wind up here, there, and everywhere else. Nothing I can do. That's not my concern. But if it is your concern, you actually have the ability to prevent that from happening, and only you do. So if that's a problem that you guys have, don't allow it. Just don't allow it. It would seem to me also, I know that we have done this before with liquor permits, that you could attach a condition to this. And the condition could be that the only thing that goes out that drawer at the bank would be medicinal marijuana. That's it, period. If a guy with a prescription pulls up to the window and wants to get his prescription, and in addition to that wants to pick up some incense and some patchouli, you can say to him, hey, listen, that's all great, but if you want that stuff, you have to come in, or you can send your kid in or something like that. This window is just for medicinal marijuana. I will defer to staff on the actual ability for you guys to do that. But it would be something, if I was this concerned, I'm not, but if I was this concerned, it would seem to me that I could attach a condition to this that would preclude anything going into that drawer that was not by prescription. There was talk at the Planning Commission that the city of Danbury was woefully unprepared to enforce the prohibition of recreational marijuana going through that drawer, because I think Director Calitro mentioned that we have 1.5 inspectors. I think the state has a vested interest in this. I know that they do when it comes to alcohol. They will send people with fake IDs that are underage to purchase. And if a purchase is allowed, they will bust the liquor store. I could see the same thing happening with medicinal marijuana. Somebody goes in without a prescription and they're sold a product and they're busted. Somebody goes in to buy a prescription product through the drive-in window and is additionally sold extra products and they're busted. I have to think with the level of investment that goes into a facility like that, that any operator would be, boy, I'll tell you, reckless in the extreme if they would allow that to happen. I'm not suggesting it couldn't happen. I'm saying that that's highly unlikely. I think with their shareholders and investors, the pressure to abide by the state statutes and all the regulations locally and at the state level are pretty high, and that would make those kinds of shenanigans unlikely. I don't want to go much further. I think Attorney Marcus covered most of this, but I do want to I do want to stress the importance of the actual reason why we're here tonight. I understand that trees have lots of branches. You put a seed in the ground and you never really know where it's going to go. I firmly believe that the city of Danbury will be able to contain any of these ancillary issues, any of these incidentals that were mentioned tonight in a timely fashion, in an effective fashion, and in a robust fashion if it has to be. But I think that to bring the incidentals up to the primary and reduce the primary down to an incidental is looking at this backwards. We're here to provide help to our constituents. This petition does that. I think that we should move forward on it. Thank you.
Thank you, Mr. Rotello. Just to go over a couple things you said, your issue of it coming before this commission in the future and us enabling or attaching conditions. Conditions are not enforceable. We don't have that right. That's number one. Number two, zoning enforcement is a huge issue in Danbury. We don't have enough staff to take care of illegal signs, chickens running between people's property lines when they're not allowed. There's a lot of stuff going on in Danbury that we can't even take care of right now. The other thing this commission has to consider is we just said no to somebody trying to sell a cup of coffee at Starbucks and selling donuts across the street. And we won in a huge case that's now huge case law in the state of Connecticut. So we have to think about cause and effect. As far as you saying that this commission should show that we're compassionate, we were compassionate when we approved it and allowed it. And the planning commission was compassionate when they also allowed it. So Danbury's done their job on being compassionate. I think Mr. Torella has done a tremendous job by offering to bring them to the cars to save people from having to get out of their car, either in the bad weather or because of their health. So everybody's done the compassion thing here, but this commission has a whole bunch of stuff to consider, and this is not a simple petition. There's a lot of stuff going on. Okay, there's a lot of stuff going on pending legislation. There's a lot of stuff going on the history of the position we've taken on drive-through windows in this area. And there's people that have been denied, especially recently. And then there's people that are going to come to us if this petition is approved and say, hey, what about me? What about me? What about me? So there is a lot of stuff going on here. What I really don't like is to have to sit here and say that if we approve this, we're all good and everything's going to be fine. We have no idea what's going to happen with the state of Connecticut, and we have no idea what's going to happen with regulation. Regulations just keep mounting more and more and more, and they get sillier and sillier and sillier, and they handcuff us. State of Connecticut just took the zoning commission's right to public hearings away from us, all right, on a petition on accessory apartments. We can't have public hearing on it anymore. It's as of right. So the state is trampling on the municipality on 169 towns, and we're one of them. So we have to consider those things. This is going to pass unanimously by a slim margin or get denied unanimously by a slim margin tonight. You know, we're going to wait to hear what everybody else has to say, and then we're going to talk about it. But, you know, this is not a simple thing as far as I'm concerned. There's a lot of good and there's a lot of not good. Anyway, commission members, any questions of Councilman Rotello at this time before I move on?
Mr. Chairman?
Who said that? Mr. Malone?
Yeah. So this is not really a question as much as it's just an additional comment or clarification with what you added and potentially from Ms. Calitro. But just to remember, a reminder also, conditions are applied to special permits, and this a drive-through use would not be a special permit. So I don't know, we could sit here tonight and anticipate that if they down the road, they were looking to open up a drive-through attached to any type of a use, they'd be before us for a special permit because that doesn't come back before us. So the ability to put conditions, I think, is actually almost impossible from that perspective.
It is possible. The other thing is somebody pulls up to a drive, if recreational marijuana gets approved and this facility has it or applies for it or pays a licensing fee for it, and somebody pulls up to the window and they want half and half, give me my prescription and I also want some of this here and there and everything else. Who's going to be there to police it? Not our zoning enforcement officer isn't going to be there to police it. So anyway, anything else?
If I may, I just want to respond briefly to just the two things. One, I was not suggesting that you had the ability to attach conditions. It was a query. I didn't know if you did or you didn't. I prefaced that by saying in the past, when we had approved liquor permits, we had some flexibility there. I didn't know if you had flexibility here or not, and thought it would be something to look into. So you don't, okay, that's fine. The other thing, my point about enforcement was not that we have a stretched enforcement operation, and that's too bad. My point was that the state has a vested interest in ensuring the success and the probity of this program. And it's the state, in my opinion, that would be doing the due diligence and the investigation, as it generally is the state that does the same thing with liquor stores. That was my point, that the burden for enforcement would not fall on Danbury as much as it would fall on the state. They have the resources to do that. There's only 18 of these in a state with 3.5 million people and a massive state bureaucracy that has the ability to do this. And with 18 dispensaries, if they even looked at one a month, I mean, they'd be doing 12 a year. I mean, that would be a relatively simple hurdle for the state to overcome. I think that if there was any indication that there was anything untoward going on with the distribution center, whether it was recreational or in this case medicinal, the state could come in and do their investigation. A couple of trips would clear that up one way or the other. I was not suggesting that the city of Danbury would be doing this. My suggestion was the state would be doing that. Thank you. Oh, and let me just leave you with one more thing. Somebody mentioned how many customers they had, and I think the number was 250 to 300. And then somebody else said, well, they're all going to come to Danbury, but then there's going to be more customers too. I don't want to be grim here, but some of those customers, they're not going to be customers for very long, if you understand where I'm going with this. The medical marijuana thing, much like a lot of things in pharmacies, in the drug, in the healthcare business, is not necessarily a happy thing. Some of these things are palliative, that they don't cure the issue, but they can ease the pain. But the arc of the disease will continue. And, there may be 300 people coming to Danbury, but in a year or two, those 300 people may be down to 250. They may be replaced. But I don't think this is going to be cumulative. We start with 300, and then a couple of years from now, we're up to 900. I think it's going. There's going to be some churn here. It's the nature of this issue. Thank you.
I understand. Also, when it was originally in front of us last June, I had mentioned to the petitioner that, and I did some research on this, and also I parked outside his facility in Bethel, and to his credit, this is the cleanest, most legitimate operation I've ever seen. However, it's not without fraud and corruption, and that comes from the doctor's office, the prescription process. There are 2 people in Danbury right now that anybody can call and say, my nerves are shot, I need a prescription, and for $50, they're getting it. Well, this gentleman on Mill Plain Road fills a prescription. He doesn't know that this person is really not qualified to get it, or is in a quick cancer patient or what have you. So, anybody, if you think, Councilman Rotella, that anybody's going to open up a business with 300 and they're going to cap it at 300 for the rest of their lives, you're mistaken. Everybody wants their business to expand. So
Look, I didn't mean that. What I meant was they're dying. That's what I meant.
Yeah, and
right. And let me just say something else. I mean, you would not ban pharmacies selling medicinal products because some of the doctors prescribing them are cheating. I mean, let's try not to have a separate but unequal thing for pharmacies dispensing this kind of medicine that we're comfortable with, and medicinal marijuana dispensing this kind of stuff that we have a problem with. Those issues that you raised are solvable but they infect the entire healthcare industry, from doctors who cheat on Medicare to everything else. Let's not, I mean, what's the next step? That we ban CVS because there's a doctor in Ridgefield who's writing scripts? We'd never even consider that. You try to fix the problem and go after them. It's the same. Let's leave the medical marijuana dispensary separate from a corrupt doctor.
Got it. So then, so
Okay.
that argument to you, and then this commission is then faced with the guys on Mill Plain Road, and this commission historically has taken a position that there should not be any drive-through windows on Mill Plain Road. So I'll concede to you that argument, and now the commission is still faced with one very solid argument that
I got that, but if I was sitting at Starbucks 5 years ago and I was looking south down Mill Plain Road to that building, I'd see a line of cars up at the window. I wouldn't know what they were doing. I'm assuming they're doing some kind of business at a drive-up window. Now I flash forward 5 years and I see a line of cars at the window still doing something. I don't know what they're doing because I'm at Starbucks looking out the window. Nothing has changed from my point of view. Yes, they would be buying medicinal marijuana instead of cashing a check, but the drive-up window exists. And if this petitioner pulls out and it goes back to being a bank, you're going to have a drive-up window there. There's no additional drive-up in this building. You already have one. So to me, I mean, conceptually, they're not banking. They're buying medicinal marijuana. It's a drive-up window. They're driving up to the window. They're conducting business. This will not change.
Thank you, Mr. Rotolo. Ms.
Thank
Khalid,
you.
your hand up. Ms. Khalid.
Oh, yeah, that's me. Sorry, I thought you were talking to Sydney. He has his hand up. I just want to correct something for the record. So in the case, this use would be considered a special exception use. A drive-through window as a principal or accessory use is a special exception on its own. So that added to a dispensary, which might be a permitted use, makes it a special exception use, just so we're clear for the record.
Thank you very much.
And Sydney has his hand up, Mr. Chairman.
Sorry, who does?
Sydney
Hey.
Almeida.
Oh, Mr. Almeida, I'm so sorry.
It's okay. Mr. Chairman, I think there's a big elephant in the room, which is about 300 pages long and sitting in front of the State House.
3-7.
Yeah, well, however long it is, it's long. We don't know what's going to happen. Would it be unreasonable to maybe table this discussion, continue it at the next meeting after, whatever actions are taken by the state, and we can kind of better gauge how it's going to impact us at the local level?
Yeah, point well taken. I think what we'll do is we will finish with those in favor, those opposed, rebuttal. And if that's the way, if that's a motion you want to put out on the floor, we'll see if it flies. But that's there's an argument to be made that it's funny. We're not talking about something that's going to happen in a couple of years. We're talking about something that's going to happen in
A couple days.
24, 25, 26 hours.
Yeah.
Oh, good point, Mr. Almeida. Thank you. I don't see any more hands, so I'll go on to anyone else wishing to speak in favor. I see Councilman Perkins. Please go ahead. Unmute, please.
Sorry about that.
That's all right. No problem. Good to see you.
Good to see you too. Good evening, Mr. Chairman, commissioners. I was able to, and I'm here to speak in favor of the drive-through. I think it's a logical progression. I had a chance to watch the Planning Commission meeting the other night, and one main thing that stuck out was, in my opinion, the incessant use of using the word edibles and equating it with food in the same sentence, in the same conversations. I'm not sure why that happened. It was, at least again, in my opinion, a little on the, I'll just say, naive side, because I think as a result, it was misleading. People with the medical marijuana card have a wide variety of conditions. Some of those people can't tolerate what we call the flower or different types of product that you smoke. They don't tolerate that. Others don't tolerate or do tolerate different types of oils. Some tolerate and use different types of edible or food sources. These edibles aren't the same as a donut. They're not the same as a hamburger or French fries. There's certain ingredients on those packages that make those products qualify for certain types of conditions, all the different types of compounds, the terpenes and everything else like that. So to use the phrases edibles and equating with hamburgers and donuts and stuff like that, that shouldn't have been done at the level that it was, not just at that planning, but they're doing the same thing here tonight. A lot was based on supposition at the planning. We're still supposing now. I mean, suppose if the federal government started on their course to legalization, a way would be decriminalization, 280G, the ominous IRS tax code, research. I think I mentioned this at one of the other meetings. Over 100 years ago, 120 something years ago, there were extracts from the bark of a birch tree that was synthesized, and the precursor came what we know as aspirin. So imagine if the federal legality peeled away different parts of those onions and allowed for scientific research. You just saw what they did with the COVID vaccines. I mean, you saw what Pfizer did, you saw what Moderna did, you saw what J&J did in less than a year. All right. So imagine taking this plant and applying those new forms of scientific technology to try to figure out different types of cures and remedies. I mean, right now, a company called GW Pharma has a patented marketable product that's on sale over in the UK for epilepsy. I mean, there's extensive research in multiple myeloma, psoriasis, correcting different conditions for weight loss, weight gain, pain management, nausea. I mean, the list goes on. So that's why I kind of had a problem with equating the medical aspect to a food, saying that if we allowed for this, anybody who wants to sell food would be able to do the same thing. And it's not. It's not the same thing. Because in order to sell the medical aspect, like Mr. Torella said, there's only 18 licenses out there. So either you get in line hoping that somebody gives theirs up and you get it, or the legislator expands the number of licenses. You can't sell that product if you aren't qualified with the medical aspect of it. So that's really all I want to say. I understand the commission's conservatism on this step, because in the past we've always been, reluctant to kind of bring dispensaries in town. Now we're treading lightly because of what we believe may be unintended consequences. But like I said at the outset, I do believe this is a logical progression for the medical marijuana program. Thank you, Mr. Chairman.
Thank you very much. Commissioners, any questions of Councilman Perkins at this time? I don't see or hear. Oh, Mr. Malolo, yes, please, go ahead.
Yeah, not a question. I just wanted a clarification just for Councilman Perkins, as well as other commission members who may be relatively new. And I just want to explain something, not meaning to be disrespectful or anything, but just an explanation, because I was also one of the ones who brought up that comparison with food. We do have our existing regulations in the CA80 zone do not allow food to be conducted or sold through a drive-through window. And so regardless of whatever action this commission takes this evening, I think it was important, and I'm probably guessing the planning commission also thought it was important, to at least let the legislative intent to be known that we did address the issue as to whether edibles would meet that qualification of food or would not meet that qualification of food, to protect the integrity of the zoning of our current zoning regulations, zoning laws, as well as legislative intent of those in anything moving forward.
Thank you, Mr. Malolo.
Thank you, Mr. Malolo.
Any other questions of Councilman Perkins? I don't see. Anyone else wishing to speak in favor of this petition?
Councilman Chianese has his hand up.
Oh, I don't see it. Councilman Chianese, please. Oh, there you are. We see you now.
Thank you.
And please.
For the record, Ben Chinese, 5 Briar Ridge Road, here in Danbury. I just don't want to repeat what was said before, but there seems to be a lot of, I think everyone's right tonight. There's a lot of reasons that were stated why we should allow it. And there's a lot of things of unknowns that says we should not allow it. But I think some of the things I just want to just get it on the record again, from my point of view, is currently, we currently allow 300 cars trips per day, whether it's 350 trips per day. That's still going to continue whether there's a drive-through there or not. That's still going to happen, whether I go there, I park my car, I get out of my car, I go inside, I get my prescription fill, I go back out, get back in my car, and I drive out, and I make my right-hand turn and I go home. If there's a drive-through there, I'm driving in, I'm driving through the window, I'm picking up my prescription, I'm driving out, and I'm making my right-hand turn, and I'm going home. Nothing changes to the fact that, as the applicant has said, there's a stated number of people are going to use this facility, whether there's a drive-through here or pickup window, as I like to call it, or not. That's not going to change at all. So, I mean, we can go on and on whether or not it should be allowed or not allowed in the CG 8020, but there is Dutchess on Mill Plain Road that does allow a drive-through restaurant and a pickup. And that's basically across the street diagonally. So there is actually a drive-up window on Mill Plain Road. So it does currently exist today. I go there pretty regularly myself. I don't see a lot of traffic coming up and down in that facility either. So I think I'm going to agree with Commissioner Almeida. The unknown is still there, and it's that over 300-page report that still needs to be approved by the governor. And I think really it needs to be tabled until that report comes out so we can fully understand whether or not recreational marijuana will have an impact in this application or not. Because I would be concerned too, if that 350 trips per day goes to 1,000 trips per day, yes, I'm going to be very concerned because that facility cannot handle 1,000 trips per day. It's way too small for that. So that would be a concern I would have that would need to be answered. But again, you're right, you can't answer it today. We have to wait those next 26 hours. But based on the testimony tonight given by Attorney Marcus, I agree with him. It should be allowed based on what we know as of today. So I just want to give my opinion. Thank you.
Easy. Hey, hand is up.
I a question.
Ms. Fay, yes, please.
Oh yeah, a question for the applicant. How many other drive-through dispensaries of the 18 are there?
Right now there's 0. I did get approved at one of my other dispensaries to utilize it in my town to do so during COVID, and we started doing that. Wasn't a drive-through window similar to what this building presents, so we couldn't continue forth with it just because it wasn't operationally efficient. Obviously, we want all of our facilities to have a drive-through for the safety of our patients and employees.
Is that your town being Nyack, New York?
No, sorry, my other dispensary facility in the town of Montville.
Where's that?
Near,
Pompville?
yeah, Montville is Uncasville near Mohegan Sun.
Oh, okay.
Oh, okay. You said it's Mountville, you said.
Montville, yep.
Okay. Thank you. Ms. Fay, anything else?
No, I don't have any other questions for the applicant, no.
Thank you. Commission members, any other questions? Anyone else wishing to speak in favor of this petition? Anyone else wishing to speak in favor of this petition? Anyone else wishing to speak in favor of this petition? Is there anyone wishing to speak in opposition to this petition? Is there anyone wishing to speak in opposition to this petition? Is there anyone wishing to speak in opposition to this petition? I'll ask Ms. Reed, Ms. Calitro, if they see any hands or hear from anybody. I don't. You don't?
No, I do not.
Thank you. No No one else wishing to speak. No one wanted to speak in opposition. Attorney Marcus, you have the floor to rebut.
Actually, the comments from the public, again, in this case, 3 members of the council have been all very supportive of this program. So I really don't have anything to add to what they've said. I think their observation on what they've heard presented by me and by the applicant, by Carl, are correct. And at this point, we would, the only thing I would say that there was some suggestion by Sid Almeida that maybe we should postpone the decision on this application to wander through a 300+ page bill that is likely to come out of the legislature the next day or so. I don't think that that's going to have an impact because, quite honestly, my read of that bill is that the sale of recreational marijuana is going to be a locally decided issue, and that, in fact, there'll be towns, and Danbury could be one or could not, there'll be towns that will not allow it. However, there's a financial incentive to allow it. In the bill itself. So I think that I go with what Ben Chanice just said. That is that this petition to amend should be granted on what we already know, and not worry about how we're going to have to legislate for what we don't know about, because we are going to have to legislate. There's a likelihood, I think, that recreational marijuana is a reality in Connecticut. And by the way, if it's not this year, maybe it'll be next year, and maybe it should have been last year. But the answer is we're going to have to legislate on how to deal with that. But in the interim, it doesn't really affect the way the applicant wishes to serve the people who need the facility. And I think we've made the case that the granting of this application is unlikely to have any serious detrimental impacts on the city of Danbury and the people of the city of Danbury, nor is it likely to set any type of precedent for what we're going to do with recreational marijuana. We've got examples in other states. Colorado was an early state to allow both medical and ultimately recreational. And the way they operate their facilities it would serve as somewhat of a guidance. They don't mix each other up. They don't mix. I mean, if you're a medical marijuana user, you go to a medical marijuana facility. If you can go in a different door for recreational, it's a different protocol. The protocol that we have here in Connecticut, by the way, was, when it was originally approved by the Department of Consumer Protection, the toughest set of regulations on the sale of medical marijuana in the country. I mean, our regulations in Connecticut were extraordinarily conservative because all of the fears that people harbor in the back of their minds, even though they say, we'd like to see this as a service to the public, we all have these little fears about what don't we know about selling marijuana. The commissioner years ago anticipated those, and the regs were tough. And Carl made that point tonight when he said, yeah, we got curbside service. You send out virtually, a licensed salesperson. He's got to be either a pharmacist or a licensed technician. I mean, you don't send out a casual employee that you've hired because of COVID and you've got a beefed up demand for services. You don't do that. You hire people who are qualified, and then you send them out there with a guard. I mean, because we are just very conservative in the state, and I appreciate that. But the commission, in deciding this, has to recognize that whatever you decide that allows the sale of medical marijuana through a drive-through window, you can really rely on the state of Connecticut to make sure that there'll be no abuses. they're tough and they're successful in this program. So I'd like you to get on with the question before the commission as soon as you can, because quite honestly, we're going to open up this facility soon. I'd like to see it opened up in the best format that we can do. So thank you. And by the way, I appreciate the commissioner's questions, because you were right on the point of what we need to be concerned about. So thank you.
Thank you, Attorney Marcus. On the subject of talking about how strict Connecticut has been and how they tailored this in a relationship to the other states, there is an issue that we talked about, but it was also briefly, and that is that since this is so highly regulated by the state, not only the product, but the procedures and the training and the operations, there's nothing in place right now by the state that dictates how someone would operate a drive-through window. So if a drive-through window is approved, there is nothing that the state provides to tell the operator how to operate that drive-through window. How are you going to, how you would make that sale, as opposed to how you make that sale when someone walks in or when someone identifies themselves in the car. So there is no procedure in place right now for the state, by the state to an operator as to how they should operate.
I think that, and just in rebuttal on that, Mr. Chairman, it would be the same operational policies that would happen today from a point of sale in terms of transactional for a patient inside the facility and or curbside for that matter. We would have to check their medical ID cards. We would have to put their license up at the door to make sure that we understand that they're in the facility or outside the facility. We would have to check our database, the state website, to make sure that they're an active patient. And then we would also have to check their allotments, making sure that they're not over their allotted amount for the month at any given time. So we would treat it at the same operational policies in terms of an actual transaction. And the last thing to note is that the drive-through would be in a restricted area, so no patients would have access to it. We would be getting the product from the vault directly to the drive-through in one fell swoop there, and it wouldn't be transported outside. It would be straight from the vault to the drive-through area, and we would be dispensing it that way.
Thank you. Also, on Attorney Marcus, on the subject matter of the state and its financial gain, that's on the recreational side. There is no sales tax on medical, right?
Correct. That's correct. To my knowledge, correct. Yeah.
So the state and the municipality make nothing off of the facility. I just wanted to clarify that as well.
They do make money off registered patients. So there is a registration fee to get their medical cards. So they are making money that fashion, but not off every sale.
Good point. If I was a patient, I would register, and my registration fee would be how much?
$100.
$100 for a one-time fee, lifetime fee?
One-time annual fee. So it would be annual fee. So it's the patients actually have to pay their prescribing doctor fee, which is usually around $150, and then the patients have to spend $100 to register with the state, and that's a recurring annual fee. There's also a fee associated with adding a caregiver as well. So there's a possibility that if you want to add your son, your husband, your wife, whatever it may be, that there's an additional fee there, and that's annual as well.
Thank you very much. Ms. Fay, did you have any comment? Oh, okay.
No, just no.
Okay.
No, it's not a question. It's not appropriate at this time.
Okay. Attorney Marcus, commission members all set with questions to Attorney Marcus? I'm going to ask the staff if they have any final comments. Ms. Calitro, mute off.
Mute off. Thank you. No, I get, well, no, yes, but I guess I would just say that Attorney Marcus's arguments or dissection of the reports and how he reads it are creative, albeit a bit convoluted, I think. And if he thinks it's not our job to bring up what could happen and the potential concerns, he ought to read the decision of ECB Realty versus the city of Danbury again and see what the judge said about that. There's no discrimination. There was no intent about discrimination relative to ADA, meeting any ADA requirements at all. And I just think that's disingenuous to bring up. In terms of comments relative to the traffic volumes, what I said in the memo was that the corridor of Mill Plain Road has been experiencing increased traffic volumes. And that, I think, again, we all experience and we all know if you've even ever tried to go through that corridor on a peak hour. So again, it's staff's position that we need to bring up the things that we're concerned about and what potentially could happen relative to kind of opening the door for additional things to be served out drive-through windows in this corridor. And I guess that's it.
Well, thank you very much. A little housekeeping here first. We have one opening of a regular member who's not here, Mr. Mazzi. So Mr. Mershon, you are sitting in for Mr. Mazzi on this particular petition. The newest commission is Mr. Eriquez, who's not sitting in on this. So the members that are sitting, I can safely say this, that on February 11th, 2020, during our training program, we did receive, on our workshop, we did receive from Corporation Counsel, and you have in your possession, the ECB Realty versus the Zoning Commission decision. So everyone does have that public record already in their possession. We did discuss it and we did talk about it. And Ms. Calitro was correct. There's a lot of very interesting points that have been made on that decision. And I think that's it. If I would entertain, what's your pleasure by this commission, a motion to either continue or to close this public hearing. I don't know if this is Mr. Almeida, if this is your grand moment here. But I'll put it out there. Is there anyone wishing to make a motion at this time?
Well, I guess it's up to me. I don't know if other people agree, but I'll make that motion to continue the meeting.
It may or it may not. We'll see what happens. Commission members, there's a motion by Mr. Almeida to continue this public hearing. I gather it's just pending to see what would happen in the next couple days. And is there a second to that? I see a second by Mr. Hawley. Commission members, this is your opportunity to discuss that motion. Mr. Melillo.
Yeah, I have one under discussion. I'm curious as to the reason for continuing the public hearing. If the reason to continue the public hearing is simply to enter into the record that the state legislature has passed a piece of legislation dealing with recreational marijuana, which in all due honesty would have no impact on this petition because we couldn't make any changes on this petition on the floor really, because they would be viewed as a substantive change in response to that action. This does currently recognize in the language that we are looking at medical and not recreational. I do understand that elephant in the room, and that could be an issue down the road that we're going to have to contend with. But I'm not sure that this petition, whether we took action this evening or took action 2 weeks from now after the state legislature dismissed, would be the purview or the manner in which we could do that. So with that, unless we were looking for more guidance, more information, just continuing the public hearing only to see if the state legislature takes action on a bill. I'm not sure we actually would need to do that, but that's just my thoughts on this matter.
Thank you, Mr. Melillo. Other commission members, any discussion? I don't hear anyone and I don't see hands. Mr. Hawley, please.
I would like to hear from more of the public. Like tonight, we only heard really from 3 city council members. Ideally, I would like to have more public input on this, which is why I second the motion to extend the hearing.
Well, I understand that, Mr. Hawley. It was noticed properly. I don't know if a continuation would gather more people, but it sounds to me like Those wishing to speak in favor spoke and opposition spoke. The sole purpose for continuing it would be just to hear what the decision was, what the decision would be. And I don't believe there'd be another public speaking portion at our next hearing anyway. I think the decision that would be made by the state within the next day or so would give the commission opportunity for discussion, possible points of discussion, but it would not open it up for any additional public speaking portions
Point of order, Mr. Chairman.
unless the motion was made to continue it for not a specific reason. Mr. Malillo.
I believe even if we had continued it for the purpose of the legislation, if the legislation was passed, if any member of the public wished to show up to speak based on the fact that the legislation was passed being the reason why we continued it, I think we'd be hard pressed to not allow them to speak.
Yeah, I suppose so. Yeah, that's a good point. Regardless of whatever the decision was by the state, if it did pass, there would be specific to that an argument potentially on both sides. So, Mr. Hawley, yes, I'll agree with Mr. Malillo on that. So there is a possibility that what your intent was could bear fruit at the next meeting. Ms. Fay, please.
If we were to continue it just because there's a piece of legislation that may be acted or will be acted upon in the next couple of days by the legislature, I think we should consider that it could happen this go around, it could happen in another session, it could happen in 2021, or it could happen in 2022 or another year. And if that were to impact our decision, that's enough to close the hearing and consider how that may impact this decision rather than waiting to see what happens in 2 days.
Thank you. Thank you very much. Mr. Jowdy.
We heard from Commissioner Almeida, his request to keep the public hearing open. And Commissioner Hawley expressed, I don't know if he had seconded or just expressed the same interest. Hearing that and the uncertainty here, I think we should respect the concerns of at least two of the commission members and keep the public hearing open.
Thank you, Mr. Jowdy. Any other commission members wish to comment at this time? Not hearing any.
Mr. Haddad, Mr. Chairman, may I offer a comment for a second time?
Yes, Mr. Malillo, of course.
I'm going to comment second and last time, noting Robert's rules. So I did mention earlier the reason for continuing the public hearing. If it was solely tied to the legislation, that being alone, I couldn't see it. If there was other reasons why people would want to consider to continue the public hearing because they wanted to gain further information, they wanted to go out and do a couple site visits, they wanted to find something they might put on the record, which really I would say commission members should not do, because what we do is we act based on what's presented in the public hearing. So really it would be the petitioner to put something on the record, or somebody speaking in opposition to put something on the record. But for us to go out and just to seek information, I would caution that that's not our purview. And then also I can think of many public hearings where we've had a petitioner stand up in front of us and no member of the public. Tonight we did have 3 while they were city council members. Each city council member, we had the 5th ward represented here, we had the 6th ward represented here. Now they may have been speaking individually, they may have been speaking as representatives of the council, or both. But you know, we did have like you mentioned, a duly noted public hearing. I would hate to see us go down, open up the can of worms that would say we're going to continue a public hearing because we had only a couple people speak or we had nobody speak. We would find ourselves continuing public hearings, I think, down the road, left and right. And so for that reason, out of all due respect, while I would normally consider a request from any member of the commission to continue a public hearing if they wanted further information relevant to the petition that required something that could be needed to be done outside of the public, with the public hearing still open, I would honor that request and support it. But in this instance tonight, I'm going to actually vote to close the public hearing.
Actually, well, thank you, Ms. Malone. Actually,
In other words, I'm going to vote against continuing the public hearing.
actually, if we close the public hearing and don't take any action on it tonight, at the next meeting, we still have the opportunity to know what would have taken place within the next couple days.
No, we can't, Mr. Chairman. If
can't
we close the
consider.
public hearing, no new information would be able to be added to the record outside of, all we would be able to do is discuss what happened this evening. And while we could discuss the fact that there was pending litigation, but we couldn't accept recognition that the legislation passed or failed, because that would be new information.
Well, even if we didn't discuss it, it's the horse is out of the barn, and it would make commission members vote a certain way potentially. Anyway, so there is a motion on the floor to close the public hearing, and there is a second. Any other discussion? Any other discussion? Any other discussion? A yes is to close the public. A yes is to continue the public hearing. A no is not to. Mr. Almeida,
Yes.
Mr. Hawley,
Yes.
Ms. Fay,
No.
Ms. Hylinski. Voice, please.
No.
Mr. Jowdy,
Yes.
Mr. Kelly. I don't, Mr. Kelly,
I think you said no. Did you say no, Jim? Put up your thumb. Oh. I don't know. There he is. There he is.
No.
Mr. Kelly, oh,
He's a no.
okay. Mr. Merchan,
No.
Mr. Malillo,
No.
and I'll vote no. 1, 2, 3, 4, 5, 6. 1, 2, 3, 6-3. That motion does not, the motion to continue the public hearing does not pass. Commission members, I would look for a motion on the D&B Wellness petition this evening. I guess to close the public.
I will make a motion to close the public hearing.
It's a motion made by Mr. Malillo to close the public hearing. Is there a second?
Second.
Second by Mr. Kelly. Is there any discussion? Any discussion? Not hearing any discussion. Commission members, a yes is to close the public hearing and a no is against it. And I need another sheet of paper here. Mr. Malillo,
Yes.
Mr. Kelly,
Yes.
Mr. Almeida,
Yes, I guess.
Ms. Fay,
Yes.
Mr. Hawley,
No.
Ms. Hylinski. Ms. Hylinski, sorry. On the rolls, I want to hear the voices.
Yes.
Ms. Hylinski says yes. Mr. Jowdy,
Yes.
Mr. Marchand,
Yes.
I will vote yes. 1, 2, 3, 4, 5, 6, 7, 8. 8-1. This public hearing is closed.
Mr. Chairman.
Mr. Malillo, is it Mr. Malillo?
Yes. Okay.
Right.
I'm here. I'm offering a motion, looking for a second, mainly for the purpose of discussion. A lack of a second will obviously say we also don't want to discuss it, but that motion is to move this to item number 2 under old business for discussion and possible action. Because if we don't make that motion, then we can't weigh any thoughts as to whether or not we want to act on this evening.
Commission members, there's a motion by Mr. Malillo to move the petition of D&B Wellness to amend section 5A, F5B2, 5B3B, 5B, F5, F1 of the zoning regulations, lead prohibition of the drive-through window for medical marijuana dispensary. Public hearing was open on June 8th. It was closed on June 8th to number 2 under old business this evening for discussion of possible action. Is there a second?
Second.
Is a second by Mr. Kelly. Any discussion? Commission members, any discussion? It's a motion made by Mr. Malillo to move it to number 2, D&B Wellness to number 2 under old business, seconded by Mr. Kelly. A yes is yes, a no is no. Mr. Malillo,
Yes.
Mr. Kelly,
Yes.
Mr. Almeida,
Yes. Let's get it over with.
hey,
Yes.
Mr. Hawley,
Yes.
Ms. Hylinski,
Yes,
Mr. Jowdy,
Yes.
Mr. Marchand,
Yes.
and I will make it unanimous. 1, 2, 3, 4, 5, 6, 7, 8, 9. 9-0. That is number 2 under old business. Let's see. A lot of writing on this paper here. Number 1 we have no other continuations of public hearings. Number 1 under old business is a petition of Newtown Road LLC, Maria Emanuel Andre, Whitney Avenue, K12254, for change of zone from RA8 to CG20. This was the March submission. Let me read to the commission and to the public who is eligible on this. Commissioners, Commissioner Almeida, Commissioner Fay, Commissioner Hawley, Commissioner Hylinski, Commissioner Jowdy, Commissioner Malillo, Commissioner Eriquez, and Commissioner Haddad. With that being said, Mr. Eriquez, I am going to seat you for Mr. Mazzi on Newtown. Thank you very much, Mr. Eriquez. Commission members,
Excuse me, Mr. Chairman.
Mr. Malillo,
Did I hear your count correct in the fact that there are 8 eligible members to vote on this evening?
1, 2, 3, 4, 5, 6, 7. Yes, there are 8.
And are there a total of 9 eligible members? If there was a 9th member here, would there be a possibility of having 9 eligible members this evening?
Mr. Kelly is not eligible because he didn't hear the tapes or watch the video, and Mr. Mazzi is not here.
But Mr. Massey, was Mr. Massey, is he eligible? I don't think he was at the last meeting, was he?
I was going to say he's not here tonight, and if he was eligible, he had to be here at the last meeting, which he was not.
So that would mean that really, as we stand right now, we only have 8 qualified voters. I'm sorry, 8 qualified members who could vote on this petition regardless of how many members are present.
That's all you're going to get.
Okay, thank you. I wanted to know that for clarification. I was just curious if Commissioner Massey's absence was making a difference on that 8 or 9.
I had 2 alternates that I could have put in, but that didn't work out either. That's correct, Ms. Calitro? That's how you see it? Got it.
That's correct. There were 8 people here at the last meeting then.
Thank you, Ms. Calitro. Thank you, Ms. Malillo. Commission members, what's your pleasure on Newtown Road? Is there any motion maker?
Mr. Chairman, I have a motion that I can offer. However, I have a little bit of reluctance in offering it. So I would like to ask Attorney Marcus first, if I may, if he would like us to, as the representative of the petitioner, if he would like us to, because we don't have to take action this evening, if he would like us to wait to see if an additional member qualifies himself, since this does need a supermajority to pass with a negative in planning, or if he is comfortable with us voting with 8 eligible members.
Mr. Chairman, may I respond?
Yes, sir. Attorney Marcus.
Thank you, Ms. Muller. I sensed where you're going, and I join you in your pursuit. It would be a lot fairer to the applicant, I think, given the fact that only 8 people heard the hearing, heard the matter last meeting, if we could have a 9th person eligible, which would require somebody to listen to the tape. But I would certainly appreciate the vote being taken by a 9-member board where I need a supermajority. It would be a big help. Thank you.
Ms. Malillo, ball's back in your court.
Based on Attorney Marcus's request, I'm going to not offer a motion at this time, Mr. Chairman.
Commission members, anyone wishing to make a motion at this time on Newtown Road? If someone makes a motion, we can act. If no one makes the motion, we would pursue the commission members that were not present to qualify themselves. So at the next meeting, we can hopefully get 9. Ms. Calitro, I'm assuming we're plenty good on time, right?
Yeah, you closed the hearing at the last meeting, so you have 65 days to render a decision. So.
Okay, great. One more time, anyone wishing to make a motion on Newtown Road? Not hearing any, not seeing any hands. We will carry that over to the next meeting, which is scheduled for June 22nd. So the way I look at it is we would want Mr. Kelly to listen to tapes, Mr. Mazzy to listen to tapes, see if we can get Mr. Nejame, right?
Or Mr. Mershon.
And 1, 2, 3, 4, 5. You're correct, Mr. Marchand. Thank you very much. Commission members, number 2 under old business this evening for a discussion of possible action is a petition of D&B Wellness to amend sections 5A, F5F2 and 5B, 3B and 5B, 5F1 of the zoning regulations, delete prohibition on drive-through window for medical marijuana dispensary. Public hearing was open on June 8th, 2021, and it was closed on June 8th, 2021. Commission members, comments? What's your pleasure? Mr. Malillo.
Mr. Chairman, I will make a motion to deny this petition and that this petition is not consistent with the plan of conservation and development because it comes with the risk of reducing the protections the city has long endeavored to maintain relative restrictions on drive-through uses, particularly in the CA80 zone. It does not meet the current purpose of the CA80 zone in relationship to the drive-through amendments. This will negatively impact the health, safety, and welfare of the general public. Again, that's tied to the drive-through restrictions that we have currently in place. And then also the existing patients of this business will continue to have access without the use of a drive-through. So we are not really hampering anybody's access to the product. We are just protecting our drive-through regulations in the CA80 zone.
Thank you, Mr. Malillo. Commission members, there was a motion to deny this petition with reasons stated by Mr. Malillo. Is there a second?
I'll second.
There's a second by Ms. Fay. Commission members, discussion. This is the opportunity for discussion on the motion, discussion on a petition. Who wants to go?
I would, I think that sorry, this is Commissioner Fay. Our regulations do and our laws in the state of Connecticut make a distinction between medicinal marijuana and pharmacies. I don't believe that it's fair to say that we're discriminating against medical marijuana users based on a distinction that this zoning commission did not make and our city did not make, but that the laws of our state and our federal government do make. Personally, I know quite a few people that do use medical marijuana, probably hundreds, and very few have ailments that are on the qualifying list. I'm not weighing in on, I guess, the societal impact on it. They are certainly, it's already come before this commission. It's going to be in our city, but it would be an inappropriate, in my opinion, it would be an inappropriate use of our drive-through regulations to extend it to a medical marijuana dispensary.
Thank you, Ms. Fay. Any other comments from commission members? Any other comments? Mr. Almeida, go ahead.
I'll just say I don't think I am going to agree with the Commissioner Malillo. I think the scope on this is very limited. I don't see there being a huge influx of medicinal dispensaries popping up on Mill Plain Road because it's controlled by the need of people with medical issues. And if marijuana is legalized for recreational use, I think if anything, that might actually adversely impact the medicinal dispensaries, because people will just go and get the marijuana from recreational dispensaries. Because this is very controlled for medicinal purposes, I just don't see the adverse impacts from having a drive-through. And I just have to say, I think Attorney Marcus's argument for them wasn't very compelling in saying that there's no difference between drive-through and curbside. But despite that, I still don't see why we should turn this down, and I will be voting, I guess, no on the negative recommendation, right? That's how that works?
Yes.
So, yeah.
That is.
It's a little confusing.
It's confusing for everyone.
Yeah.
Well, thank you, Mr. Almeida. Any other commission members? Ms. Fay?
I'm sorry, I was thinking about this during the presentation. I didn't comment. And I am very familiar with Mill Plain. I go there several times a week, and I'm at Duchess and or the Chinese restaurant across the street at least once a week. And the traffic is atrocious. As someone said, you know, the Mill Plain corridor, and one of the prime times, I believe Mr. Torella said, would be Friday between 4 and 6 p.m., which I don't think is a coincidence. Is not when I fill my prescriptions on Friday evening. But if this is going to be a prime time on Mill Plain Road, that is bumper to bumper. And we all know it. Everybody gets off of 84 to come through Mill Plain. It is bumper to bumper for miles and miles for a couple of hours, especially on Friday evenings. And even right now on a Saturday morning or, you know, Saturday afternoon for lunch when I'm pulling at a Duchess, it's a difficult turn to make. I mean, I think this position at 105 is, you know, has a little bit of advantage there just because it's at the stoplight. But the right turn only is not enforceable. I understand we recommend people turn right out of parking lots. They're not, that's not an enforceable regulation for anybody. So I think the added traffic, if somebody lives in Wilton and they can go to Stamford and have to get out of their car to fill their prescription, or they can drive to Danbury and go through the drive-through, quite a few people would probably be lured to the Danbury location rather than the Stamford location, even though they're equidistant. So I think we would be looking at an increased capacity of clientele or patients in the Danbury location based on the drive-through.
Thank you, Ms. Fay.
And Mr. Chairman, I would just add to that, if I may. As I understand it, for someone who lives in Wilton to come to the Danbury facility, they would have to be registered with that facility. So it's not as easy as, you know, just picking up and deciding, oh, I don't want to go to Stamford, I want to go to Danbury because it has a drive-through. They have to be registered with that facility. So, you know, I think that would kind of limit it. Some of the, you know, people that would come to Danbury specifically because of that drive-through. So I don't think that's a big concern. The traffic's going to be there regardless of what happens here, whether it's a bank or any other use. It's going to have an impact on the traffic regardless. I don't see how this is going to have extra impact on the traffic.
Thank you, Mr. Yes, that's correct. If you're registered at one place, you can't go hopping around, but all new registrants possibly in Wilton, if they had an opportunity, if they were brand new and they had an opportunity to select their locale, might pick because of that. Maybe not, whatever, but that's what that, I think, conversation meant. Else, Ms. Hylinski, Mr. Hawley, Mr. Jowdy, Marshawn, anybody have any other comments?
Mr. Malillo.
Mr. Malillo, sorry.
That's okay. I just want to add to the comment you just made, and also while that you do have to register, I believe you can change registration. You can petition to change your registration And I think if you made the argument to the state that this Danbury location is more suitable for me traffic wise or convenience wise or distance wise, I think the state would probably be apt, I could be wrong, but my guess is the state would be apt to approve that, knowing that that's your new locale, you can't bounce back, because I think the whole reason for the registration is to keep you from bouncing back, to make it much more available for tracking purposes, and make sure that you're not going over the quantity that you're allowed to. I think that's probably the purpose for the registration, and that would, I think, be honored. So while I would agree that with the registration, being a difficulty, I don't necessarily being an impossible hurdle for somebody to achieve if they wanted to switch over to Danbury. And again, I just want to remind the commission or the commission members that part of the reason for me making this motion, I know I've had I have a history of voting against medical marijuana. I don't think I've voted for one yet. However, this one I'm also largely weighing the drive-through restrictions, our drive-through laws, and looking to respect the integrity of those in their existence. I'm really trying to weigh the two right now on this one, so it's not just all about medical marijuana.
Thank you. Any other comments? Mr. Hawley, please.
Yep. So I believe this will positively affect the members that will be using this facility if this were passed. So I don't believe it will negatively affect the general public that will be involved with this change.
Well, thank you very much. Any other comments? Mr. Kelly, Mr. Jowdy? Any comments? I generally don't at this stage, but I will just have this to say that I'm very thankful that there are opportunities historically and that will continue for the curbside service. And I thank the applicant for expending their 2 employees for the time in doing it to make it easier on the people. I think I'm leaning toward removing the concept of medical marijuana out of the equation and just say that I've always been for protecting those areas against drive up windows. So, that's where I'm coming from on this petition. And I'll ask one more time if anyone has any more discussion on this. There's a motion to deny with reasons, and there was a second. And I don't see anyone else wishing to discuss it. So we're going to put it to a vote. So where are we now? So a yes is to deny. So a yes is to agree with the motion to deny. A yes is no, a no is yes. Mr. Melillo.
You gotta love zoning commission terminology and vocabulary. I vote yes.
Ms. Fay.
Yes.
Mr. Almeida.
No on the negative recommendation.
You got that? All right.
Which is a double negative.
Mr. Hawley.
No.
Ms. Hylinski.
Yes.
Mr. Jowdy.
Yes.
Mr. Kelly.
No.
Mr. Marchand.
No.
I will vote yes. Did I miss anybody? 1, 2, 3, 4, 5, 6, 7, 8, 9. 1, 2, 3, 4, 5, 6, 7, 8, 9. 1, 2, 3, 4, 5. 5-4, the motion to deny passes. Is that correct? Ms. Calitro, you show the same numbers?
Yes.
Ms. Reed, thank you very much.
2, 3, 4, 5 to 3. Yes, to deny.
5-4 denied.
5 to 4. I'm sorry. 1, 2, 3, 4. Yep.
Thank you very much, everyone. There is no new business. There is no correspondence. Are there any other matters? Are there any other matters? Are there any other matters? We don't have any for reference only. So let me remind this commission that we do, unless, I don't think we're going to get anything new, but we have a June 22nd meeting for the Newtown Road petition. Is there anything else to add? Ms. Reed?
We got a petition in for a liquor license, so we'll be doing that on June 22nd too, at the entertainment venue on Mill Plain Road that went in where Sportland was. They're having a cafe in there.
Okay.
We'll be doing that on June 22nd also.
Okay, so commission members, we did pick up something new. So we are going to have two hearings on the 22nd. And I'd really like to see if we can get those 9 people for Newtown Road. Anything else, commission members?
Mr. Chairman,
Mr. Malillo?
I would just like to recognize and thank Ms. Agura for sitting through this meeting. I know she had an interest in one of the items and we did not act on it this evening. So I did want to apologize that we were not able to let her know earlier, but we really couldn't have known at the beginning of the meeting that we were not going to act. But I did want to at least recognize that she was here and thank her for being an interested citizen in the matter.
Thank you.
No worries. Thank you very much.
I see that there's somebody else here that didn't get to that as well. Anyway, is there a motion to adjourn at 10:29?
I'll make that motion. Let's go home.
Adjourn at 10:29, second by Ms. Hylinski. Any discussion? All those in favor signify by saying aye.
Aye.
Opposed? That's unanimous. At 10:29, we're adjourned. Thank you, everyone.
Thank you.
Thank you.
Thank you.
Everybody.